Welcome. Well, I see everybody got up early. Welcome to the Senate Business and Professions Economic Development Committee hearing on creating a seamless enforcement program for consumer boards. I would like to thank, never mind, we'll leave that for later. I want to acknowledge our speakers who've traveled to Sacramento to testify on this important issue. Last month, the LA Times, in partnership with ProPublica, published a series of articles criticizing the timeliness of disciplining problem nurses by the Board of Registered Nursing. These articles were, in my opinion, very damaging to the mandate of the board to protect the public. However, I am also aware that timely disposition of disciplinary cases involves other state agencies, namely the Department of Consumer Affairs Division of Investigation, the AG's office, and the Office of Administrative Hearings. We recognize that lapses in the enforcement programs of health care licensing boards is just unacceptable, and there is a need to streamline the process at all agency levels to ensure that the public continues to be protected. There have been several proposals and recommendations that have been introduced to address the enforcement backlog. At the Board of Registered Nursing August 12th hearing, the Department of Consumer Affairs had several recommendations to increase accountability, promote greater efficiency, and putting consumers first. In addition, the Center for Public Interest Law will also testify today about the recommendations. Thank you. The backlog paper for this hearing also includes the Center's recommendations as well as others from the Board, the Department of the Attorney General's Office, and committee staff. The goal of this hearing is to understand the underlying causes of the delay, listen to additional recommendations, in particular from the Department, and get feedback from any of the recommendations in today's hearing. Our first panel of witnesses consists of Ann Boynton, the newly elected president of the Board of Registered Nursing, Louise Bailey, Stacy Burnham, and Carol Stanford on behalf of the board to testify on the board's enforcement and diversion programs, the board's plans in addressing the delays. And with that, we can go ahead and start. If we could have Ann Boynton come forward, Louise Bailey, Stacy Burnham, and Louise Bailey.
Oh, they changed it.
Yeah. Go ahead, introduce yourselves. And if you'll leave it on, just it'll stay on. Yeah, thank you.
Ann Boynton, Board President.
Louise Bailey, Interim Executive Office of the Board of Registered Nursing.
Stacy Berman, Enforcement Division Chief for Board of Registered Nursing.
Okay, so go ahead and start. Which of you wants to be first?
I'll go ahead and start. Thank you very much for the opportunity to be here this morning. We share the concerns that you expressed in your opening statements around the delays that have been occurring in all of the enforcement and in diversion cases, both within the board. We, as the board, are firmly pledged and positioned to make the improvements necessary to ensure that these delays do not continue. We're working closely with the administration. As you heard the director last week announce several proposals that the administration is pursuing. We certainly support and endorse the administration's involvement and continued activity in that area. We as a board will continue, however, to do our own analysis of the processes that are in place within our board, recognizing that time is of the essence and that change will take, policy shift takes quite some time, but at the same time we have an enormous mandate to protect the public immediately, and that's where our focus will be. So thank you very much for being here.
The Board of Registered Nursing, in order to ensure the safety of the consumer, we look at the licensing issue in terms of making sure that the nurses are licensed as they should be and that they meet all the licensing requirements. And also we do this through our licensing and also enforcement. And the BRN's licensing program is the initial consumer protection area that verifies that all RNs are properly educated and trained, they're fingerprinted, and have successfully passed the national licensing examination. The Board of Registered Nurses Enforcement Program responds to complaints regarding unprofessional conduct by registered nurses, which includes but is not limited to incompetence, gross negligence, convictions, out-of-state discipline, and or discipline that has been taken on any other health issue. Currently, we have 365,000 registered nurses, of which 350,000 of those licenses are indeed active. And we have been struggling for quite some time, for a significant time, with the backlog of cases. And we feel that this certainly is unacceptable to the board, but we are committed that we're going to work with the Department of Consumer Affairs and whomever in the AG's office in order to make some serious changes. Last week, our new Department of Consumer Affairs new director, Brian Steger, presented a framework that outlines the groundwork for enforcement reform. And I'm very optimistic about this framework because then we can finally have the discussion that we need and should have had around truthful and meaningful reform, and so that it can be a reality for the boards. And this framework is a work in progress, and it will further identify and eliminate insufficient or duplicative processes so that we can create a more highly standardized and more accountability. Now, as Ann said, the Board of Registered Nursing and its members are absolutely committed to protect the consumers with fast, thorough, and efficient complaint investigations, and we will leave no stone unturned as we look for ways to streamline the enforcement process. Over the years, our process has been when we get complaints on nurses, they're evaluated at the board, and they're sent forth to the Division of Investigation. Well, the Division of Investigation has not always been fully staffed, and thereby, and also they have other boards that they are doing investigations with, quite a few boards, not just our board. And so with that, we know there's some options that we have been looking at, and I'm going to let our Chief of Enforcement expound on those. But we are looking at having our own investigators, and we'd like to have some attorneys assigned strictly to our board that will focus strictly on nursing. We feel that would be in the best interest of the public with that kind of a focus, and that we would then be able to truly expedite our cases. The bottom line is that the delays in the investigation enforcement are due to a variety of reasons. Some of them maybe we can streamline what we are doing at the board. We cannot put all the fault on just one or two entities. So we feel that while these proposals have just been made, the stage has been set to establish a new standard for licensees and establish a new level of trust with our consumers, because the system is broken, but we are committed to fixing it once and for all, and we will enlist the help of our licensees, any partners, the administration, to create a system that is second to none. And patient safety is our driving force, and consumer protection is our mission. Thank you.
Mainly, I'm going to go over a report that I had provided to the department.
Please.
I'm sorry, Stacy Berman, Enforcement Division Chief with Board of Registered Nursing. I will be going over a report that was provided to the department at a hearing on July 27th, 2009. And I wanted to thank you for allowing me the opportunity to come and speak before you this morning and provide this information to you. As Louisa said, our enforcement process can be a complex process with several steps for those cases that complete the process from original intake to disciplinary action. Each step along the enforcement timeline takes time. A complaint must first be processed and reviewed, then investigated, forwarded to the Attorney General's office, returned to the board for approval, returned again to the Attorney General's office to serve on the licensee, referred by the Attorney General to the Office of Administrative Hearings, and then forwarded back to the board for final disposition by the Board of Registered Nursing's board members. From the initial receipt of a complaint to the final disposition, the average timeline for 2008-9 was 3.4 years. The BRN has identified a number of possible causes of our unacceptably long enforcement timeframes, which include obstacles that the board has faced related to its administration, to its processes, and to the statutory framework within which we must operate. The barriers that we see is that we have been understaffed. Since 2001 and 2002, complaints have increased by 275%, while the number of staff are only increased recently in January of 2009. The department's current standardized method for tracking cases does not allow staff to adequately manage the inflated caseloads that we have. Therefore, we have created duplicative systems to which do not interact together and require multiple entries in order to monitor the status of each case. The department has been unsuccessful on 2 occasions to update the obsolete system that is currently being used. The Division of Investigation, which is under the Department of Consumer Affairs, are the board's investigators, and they handle our more complex enforcement cases. They also investigate cases for most of the other boards and bureaus within the Department of Consumer Affairs. They currently have approximately 38 investigative positions with 31 filled and have approximately 100 cases each. Our statistics show that it's difficult for investigations to be completed within reasonable time frames with an overall average of 17 months. The Office of the Attorney General is our legal representative, and they are under the Department of Justice. As well as the Division of Investigation, they handle cases for a number of boards, bureaus, and commissions in addition to our cases. Our data shows that it takes an average of over 17 months to complete the administrative adjudication of our cases. The efforts that we've made to improve enforcement have already begun. We've taken steps to improve our program, and the steps have brought changes to both complaint and investigation process and the disciplinary process. The changes have focused on administrative, procedural, and legal impediments that face the board and can be found in the report. Our immediate next steps administratively, in order to address the staffing shortages in our enforcement unit, the board board staff will seek approval to increase enforcement staff by approximately 63 positions. These new positions will augment existing operations in the complaint unit, enhance probation and diversion participant monitoring, and manage disciplinary cases. This increase is necessary to process and manage complaints and reduce analyst caseloads to approximately 150 cases each, and establish staff to initiate internal investigations that include obtaining records, conducting interviews, and having nurse consultants perform initial review of quality of care cases. This increase will also support the improved monitoring of probationers, managing diversion program participants, preparing accusations, serving default decisions, managing Division of Investigation and Attorney General cases, and responding to Public Records Act requests. It is recommended that the board seek to enter into a memorandum of understanding with the Attorney General's office to establish performance goals with the Deputy Attorney Generals to assure that timely discipline of licensees. Board staff believes that a timeline of 9 months or less is ideal. Under this agreement, the AG should provide monthly statistical reports for public discussion at our board meetings. Procedural changes, it is recommended that board staff serve accusations and notify the Deputy Attorney General working the case when the notice of defense is received. Additionally, board staff recommends working with the AG's office to develop templates and train staff to prepare default decisions, out-of-state discipline, and the less complex conviction pleadings and less complex petitions to revoke probation. Legal, consistent with the recommendation to increase staffing in its enforcement unit, is recommended that the board consider seeking emergency regulations to increase licensing fees to an amount necessary to support the proposed staffing augmentations. Board staff recommends obtaining statutory authority to obtain any records relevant to a case, including but not limited to medical records, personnel records, controlled substance records, and internal investigations from healthcare facilities without a patient release form or subpoena. This change would significantly reduce delays in our investigations, and additionally, the board would seek authority to fine licensees and facilities for failure to comply with requests for records, similar to the process utilized by the California Department of Public Health. Board staff also recommends changes to the diversion program to improve enforcement and protect consumers. First, the board should have authority for the automatic suspension of any diversion program participant who does not successfully complete the requirements of the program. Additionally, the board should have the authority to continue an investigation after a licensee is referred to the diversion program, rather than closing the investigation, and to disclose participation to the Division of Investigation for all complaints that are referred to the diversion program. Other possible systematic changes that we've looked at, in addition to the changes that can be made immediately, there are a number of other possible changes that the board can make in the future to improve its enforcement program. The enforcement programs from other licensing boards and other federal, state, and local agencies can be examined for improvement methods. For example, the board could seek immediate suspension authority where a license can be suspended on the spot pending a hearing, which is available to the Board of Behavioral Sciences and the State Athletic Commission. Some of the other changes recommended above have been made by other licensing programs within the department. Changes to the Division of Investigation that should be considered include hiring non-sworn investigators assigned only to the board to obtain records and conduct interviews, and requiring that the Division of Investigation provide investigations of administrative cases to the board up front rather than waiting until the investigator completes the criminal portion of the investigation. Other specific recommendations include adding investigators directly to the board staff and assign a dedicated administrative law judge and deputy attorney general to the board. Further, the board staff recommends that the department look into hiring its own prosecutors that could be utilized by all boards and bureaus within the department.
And I would like to add to this that with our proposal in terms of the increase in staff, we would need to have the authority to also increase the fees, the nursing fees, okay, because those fees have not been increased in over 18 years.
Okay, so, okay. And everybody's on board with increasing fees? Is that, do you think that'll help you?
We do think that'll help us. At our meeting, the board met last week and authorized the staff to proceed with promulgating regulation. We have statutory authority for, we have room within the statutory limit for our fees to increase them without additional statute, and we will be initiating the regulatory process to increase those fees. We believe that the profession will be supportive of this.
Right.
Their only issue was the fact that our staff is currently on furlough and that we are out of the office 3 days a month. That was their only sticking point to the fee increase, is that they are opposed to increasing fees if we are not allowed to work full-time in our offices, as we have the authority to do.
Well, this is not going to be ongoing forever.
Right.
You understand that? I mean, the economy at some point is going to go off. This is going to go off to the wayside. So that can't be an excuse.
No, but they wouldn't oppose it if once the furloughs go away, or if we were allowed to work full-time.
And what do you propose? You want us to kidnap the governor?
No, I understand. No, I understand that you authored a bill that you were working towards that goal. So,
those who spoke at the board meeting had that as a concern, and ensuring that existing vacancies within the board staff are filled, and certainly filling vacancies is a primary issue as well. So their interest is ensuring that our staff are working efficiently and effectively, and that their dollars are being used for the highest and best use in support of both licensing and enforcement activities for their members, and we are fully behind that. So we'll go through the regulatory process. We'll see what sorts of comments we get around that. But currently, the process is underway for us to promulgate new regs to increase the fees.
Okay, so tell someone that's outside of your realm, out of your profession, what happens when a nurse, male, female, whomever, something happens in a hospital. What happens if something bad happens? What is the first step? What happens in a hospital?
Well, usually what happens in a hospital, we may get a complaint. We may or we may not. We do not have mandatory reporting at this point in time.
And do you think that would be a good idea?
I think so. In terms of those egregious cases and where there is patient harm and patient death, yes, I think that it should be reported to the board immediately.
As well as drug diversion.
Yeah. So drug aversion as well, so that we can take some action on it. But sometimes things happen in hospitals that we are not aware of, or they may happen in the hospital in the Department of Public Health, license and certification. They go out to investigate, and then after their investigation and all, they may send us a report that indicates that there was a nurse that was involved, and then we can go out and do something. But sometimes, see, we don't know till after the fact.
Right.
But there may be something that we could work closer together with the Department of Public Health, license and certification, so that they would notify us immediately if they think there is a nurse that was involved in some act. So we need to work closer, I think, with some of the other departments.
Let's take it outside of the realm of a hospital. Let's take it a realm in a doctor's office. What happens then? Same thing?
Same thing. We'd have to wait for the doctor or the patient or a family member or someone to notify us, because we don't know. And once again, there isn't mandatory reporting, so we get the complaints later down the line sometimes.
Do colleagues report other colleagues? Is that
occasionally? But no, that is not, occasionally they will report.
But if a colleague saw someone committing egregious acts, wouldn't they be kind of bound? I don't swim. However, if somebody was drowning in front of me, I had a phone, the first thing I'd do is call 911. I wouldn't just stand there in the river and say, oh my God, I don't swim. So,
right.
Too bad. You know? I mean, don't we all, as a societal kind of thing, need to report each other if we see something that's egregious or something that it's not something that we would do? I don't mean just piddly stuff.
Right. Yes. And we should, because within our standards of competent performance, we have one standard that says that the nurse must be the advocate for the patient. Thereby, if the nurse sees something adversely happening to that patient, he or she does have a responsibility to intervene and do something about it. And someone should report it to us. But like I said, without mandatory reporting, we don't get that all the time. But there are those who do report.
However, we had a hearing here on physicians, and their big complaint was that one colleague could say another colleague did something. How do you prevent that in the nursing field?
Well, that's our issue as well.
Yeah.
We do have to deal with those complaints that would be considered frivolous, where they would be from colleagues or ex-spouses, girlfriends, boyfriends. We do deal with those as well, and so those complaints also clog up investigating legitimate complaints.
Because you have to honor that due process.
Right. When a complaint comes in, we have to determine whether or not there's any truth or fact to it.
Right.
But wouldn't that run through the system pretty quickly? I mean, in most cases, you'd probably be able to weed out frivolous.
It depends on the information that's provided. Yes,
right.
If it's an anonymous complaint, we can rule those out. However, if they provide information that would warrant having an investigator come do an interview, then those do take longer time.
Okay. Any other way that you could see that this process could move faster? And what are you going to do about diversion?
Okay, I will present something on diversion. Would you like me to go forth with this?
Well, can you like?
Oh, you want me to wait?
Or were you going to do it later?
No, it's part of this.
This part of this.
Yes.
Yeah.
Okay, so go ahead.
Okay. Now, you know, the diversion program is a comprehensive rehabilitation monitoring program, and is available to any licensed registered nurse that has not been disciplined by the Board of Registered Nursing for drug, alcohol, or mental illness related to violations in the Nursing Practice Act. Registered nurses are referred to the diversion program in several ways. They voluntarily enter the program program directly, or they are referred by a friend. It could be a family member. It can be an employer. It could also be a colleague who recognizes that that registered nurse has a problem with drugs and alcohol, or maybe have some mental illness, and we get it through a complaint that comes to us in terms of their misusing of drugs or diverting drugs.
What about self-referral?
They can self-referral. Yes, they do self-referral. Some of them also self-referral. And so now, once we get a complaint on a nurse, and it is for drug chemical dependency, as we call it, or mental illness, we do offer them the diversion program. We offer to each and every one that we have a complaint against. Now, it's up to the nurse to accept our diversion program. If he or she does not accept to come into our program, then we continue on with the investigation. Okay? Once the person comes into the diversion program, then the investigation ceases at that point in time. But at that point in time, when they agree to come into the diversion program, we suspend their nursing practice and agree with them that they cannot practice nursing. They must cease working immediately. Then an assessment is done on that individual, and they go to what we call a diversion evaluation committee. We have 13 of them throughout the state of California. The diversion evaluation committee is comprised of a physician, nurses who specialize in chemical dependency and mental health, and there's also a public member on the diversion committee. And they meet with that individual and assess the person, and they develop a rehabilitation plan for that nurse. And it might be that they have to go to alcohol.
Somebody needs to turn their phone off. In fact, everybody turn your phones off. Excuse me.
Okay. And they may be referred to Alcoholics Anonymous. They may be referred to Narcotics Anonymous, or they may be referred to support. They are referred to support groups. They may have to have a psychiatric evaluation. That group indicates they develop a comprehensive plan for that nurse in which that nurse must follow. And then a contract is signed by that nurse that she or he is going to abide by that. And I know we did have that adverse article in the LA Times because there was a nurse who was in the diversion program who went out and got a job, which she was not supposed to do. So we did act on that, and we have rectified that in that any nurse who comes into the diversion program, the license is placed on inactive status.
What about the article also stated there was a nurse who missed their drug testing 36 times.
Yes.
How does that happen?
Really can't answer that, to be very honest. I don't know how they're monitored, but and when they're monitored like that, when they miss those drug tests, we should have moved that case forward. It should have gone forward. Yeah, that's right. Yeah, but one thing, we need to have more individuals who are monitoring those individuals as well. We do have
Where is the disconnect with that?
Well, we do have a company named Maximus, yes. And Maximus is the entity that does a lot of our follow-up. They're the ones who make sure all the drug testing is done and the whole bit.
Well, they make sure, but they didn't make sure.
On this one. Correct. Yeah. So
where's the disconnect there? How come nobody's watching the company? You're paying them. Why isn't anybody?
We are. The board is beginning to. We've met twice since the new members were appointed.
What was the rationale?
We do not yet understand what the issues are relative to the diversion program, nor how the contractor is implementing it. That these circumstances could possibly have occurred, and we are initiating an investigation into those actions.
What's the percentage rate of success?
The percentage of the success is like 40 to 50%.
For those who enter the program.
Enter the program. 58%, I think it is, something like that.
58%.
58% of them
What
are.
happens to the other 48%?
They fall out, and then they go through the disciplinary route. That's what happens with them. We have 500, a little over 500 right now who are in the diversion program, and we've had approximately 1,400 who have successfully completed the diversion program. Those who are
About recidivism.
I can't speak to that, to be very honest with you, in terms of how many return.
I think what you need to do for us is you need to tell us how many actually go through the program, what's the success rate, but then you got to tell me
Right. How many
come back?
How
many relapse?
how many stay clean.
And the board needs to know that too.
Right, yeah.
We need to know that.
We do not
So
yet know
somebody
that
asked
information, but yeah, I completely agree with you.
Because when they relapse and they go through the disciplinary process, if they try to come back to the program, we do not allow them back into the program.
Now,
See?
what happens to those that do not succeed? Do they lose their licenses?
If they do not succeed, then they go through the disciplinary process. They may lose their license. They may be placed on probation.
How many nurses lose their license?
How many lose their license?
Do we have a count for
Given
last
time.
year? How
Yeah,
many
given
licenses were suspended or revoked?
I don't have that data in front of me.
Okay, we need
But
that
I know
data
that.
too.
Okay, fine. You don't know.
No, I don't know.
We don't have
I'm
that.
sorry.
Had we known, we could have brought that forward. Yeah. So also with these nurses, when they're in the program, those who are chemically dependent, are using the program for about 4 years.
But if they do not complete the program and they come back in, should they lose their license? That's a question. Should they lose their license? Should they not be able to practice? Because they could harm society.
Right.
They could, so they are if they fail out of the program, they go into the enforcement process, as would anyone who through any other complaint process. And some of those individuals may have the same sorts of behaviors, and the investigation then would determine whether or not we have the latitude to suspend them.
Yeah. So some of them may very well lose their license.
But do they cease practice at that point in time? If they pop out of the program, can you go after them to stop their practice?
Once they come, yes.
Only if we have
I thought
the.
you were asking to change that.
Yes, we are.
authority.
Yes, we are asking for that authority as well.
But like I said, once they come in the program, they're going to be on inactive status as of now. Well, some weeks ago, we're placed on inactive status. So thereby, if they fall out of the program and they go the disciplinary route, their license is still inactive. They cannot work.
Okay, tell me what happens when somebody gets hired in a hospital. Do they have to present their license that it's current?
Yes, and it's up to the employer
The employer
to
checks.
check to find out if that license is clear and free of any disciplinary action.
If I have a license who is suspended and I go to an employer, but if the employer doesn't check, there's nobody that's going to come after me to check me.
Right,
and if I go to work for a doctor's office or a clinic, and they don't have the time, they don't have the stuff, I conceivably could be working with a suspended license. Is that correct?
Certainly. If the employer does not do their due diligence and ensure that an individual they are hiring, representing themselves as a registered nurse, does not in fact carry a valid license, yes. But that's an area that I frankly believe is outside the board's control. We can't force employers to do the due diligence that each and every one of them ought to be doing.
That's right.
Is the invalid, inactive status anywhere that anybody can look for it?
Yes, when they go on the website and put the person's license number in or the name, and they click on it, it will say inactive.
So an employer of any size of institution or anybody, then they could find it readily.
Absolutely.
Yes, 24 hours a day.
Any member of the public can as well.
They would be liable because they didn't do due
They did
diligence.
not check it, right.
All right.
We have that system open 24 hours a day.
Thank you, ladies. Since we only have 3 hours, we're going to go ahead and move on. Thank you very much. The next panel is the Agency and Department Consumer Affairs. Laura Zuniga and Brian Stigler. Come forward, please. Good morning. I see you a lot, huh?
New director.
And the director, new director,
Good morning.
do I say congratulations or do I say
Very excited.
condolences? Which? Go ahead.
Good morning, Madam Chair. I'm Laura Zuniga, Acting Deputy Secretary for Legislation for the State and Consumer Services Agency, and I appreciate the opportunity to be here today. The administration is committed to reforming the enforcement process that we have in place right now for our health licensing boards to ensure the welfare of consumers always comes first. Recent events have shown that our current process is not working. We don't want to fix the current system, as a disciplinary system that takes 3 years or more to complete is not acceptable. Instead, we believe we need to implement a new enforcement model, one that is focused on greater efficiency, increased accountability, and that puts consumers first. I'm going to defer to our Director of Consumer Affairs, Brian Steger, to provide an outline of our plan. But first, I'm also going to provide an update on the Department of Consumer Affairs implementation of SB 1441. This legislation, which took effect this January 1st, established the Substance Abuse Coordination Committee, comprised of the executive directors of DCA's Healing Arts Boards, as well as a representative of the California State Alcohol and Drug Program, to develop uniform standards by January 1st, 2010, in 16 specific areas that all Healing Arts Boards shall follow in dealing with substance abusing licensees, whether or not a board has a formal diversion program. The committee met in March to discuss the requirements, and they convened a staff working group to draft the 16 standards. They have drafted standards 1 through 6 and met in May to review them, and then the working group is continuing to draft standards, and they will have another public meeting on September 2nd. And then on September 30th, and plan to have everything drafted by the public hearing November 10th, and then we'll have them submitted to the legislature by January 1st of next year. So I'm going to turn it over to Brian. I just also want to say that we look forward to working with the committee, the legislature, consumer advocates, and professional associations to develop a new enforcement system.
Good morning, Madam Chair, committee staff. I'm Brian Steger, Director of the Department of Consumer Affairs. All of the Healing Arts Boards under the Department of Consumer Affairs have been struggling with significant backlogs for a period of time, and this is unacceptable. And the Board of Registered Nursing will work with the Department of Consumer Affairs, the State and Consumer Services Agency, and the administration to ensure significant improvements going forward. Last week, I presented a framework for enforcement reform model. I'm very excited about this because we can finally have a discussion that will make true and meaningful reform a reality for all the boards. My department is working closely with the State and Consumer Services Agency and the Governor's Office, and we are absolutely committed to working with our partners to secure the tools necessary to protect consumers with fast, thorough, and effective complaint investigations. We will leave no stone unturned as we look for ways to streamline the enforcement process. I want to be clear that this enforcement model recognizes a variety of effective methods to reduce these egregious backlogs. I'm very familiar with the internal workings of a Healing Arts Board, having served as an executive officer. There is not going to be one magic bullet that turns this program around. The delays were created by a variety of factors, and the solution must be a multifaceted, comprehensive plan. Many options will be considered, and one may include hiring more investigative and legal personnel, as justified by workloads and public safety. This also may include hiring civilian investigators and paralegals. Each board should anticipate mitigating the new costs with possible increases to licensing fees, several of which have not been raised in over a decade. That being said, the proposal to hire more investigative staff is not the final solution. Our enforcement model is not carte blanche to throw money and staff at a widely systemic problem. Many other problems have to do with accountability and reorganization of resources that already exist. For example, the Board of Pharmacy relies on field investigators who are required to mail paper case files to each other as the case winds its way through the enforcement program. We could shave off weeks if these cases were transmitted electronically. The Pharmacy Board has already begun to implement this effective streamlining method. Like the Pharmacy Board, every board needs to assess its own roadblocks, take responsibility for the ones that can fix, and speak up about the ones that need help eliminating. It is my job to begin asking the difficult questions in order to bring about successful results. I know that there are many places where boards can tighten up their timeframes and enforce accountability, and as a result, improve their work efficiency. That is why we are excited about an enforcement framework that has been proposed that not only strengthens our ability to act quickly. Going forward, the framework will also make statutory changes that will help expedite the various steps that are required when investigating and taking enforcement action against a licensee. We also welcome any authorities the board executive officers can exercise to suspend any license if a licensee fails to produce documents or participate in an interview without proper notice, or to suspend a license or refuse a renewal for any person who is incarcerated or held in jail or prison for a felony. I welcome proposals that broaden an executive officer's authority to revoke or suspend licenses within a reasonable time frame so that consumers are protected from licensees who may pose a threat to consumer safety. This is not sacrificing due process. That is just being smart about not accepting a 3-month delay to get a harmful, reckless licensee away from consumers. This framework is a work in progress, and we will further identify and eliminate inefficient or duplicative processes to create a much higher standard of accountability. While many of these proposals have just been made, the stage has been set to establish a new standard for licensees and establish a new level of trust with our consumers. Patient safety is our driving force, and we will never again allow it to become the victim of bureaucratic inaction. The system is broken, and we are committed to fixing it once and for all. We will enlist the help of our licensees, partners, and the administration to create a system that is second to none. Our licensees and our consumers deserve nothing less.
Now, let me ask you a question. What's the extent of your backlog?
Well, there's backlogs across the entire department with all of our healing arts boards.
Okay. I'd like some figures, if you could present those to us at some point.
Okay.
Okay. Now, everybody has talked about here in the legislature, and I know the boards have talked to us about the furloughs. That seems to be an impediment to moving forward. How do we work around that? How do we do that?
We just have to work smarter with the resources that we have.
Oh, okay. Well, that'll work up to some extent, but
I think, Madam Chair, I think the boards will need to work directly with the administration to demonstrate the need for flexibility. I mean, we'd like to see a comprehensive plan to change enforcement, and I did hand out a copy to you to summarize what we're looking at, and I think a lot of our recommendations correspond with recommendations you've made. I mean, the timelines for investigations were unacceptable for the furloughs, so we would need to look at a comprehensive solution to see, what changes we can make and look at the impact of the furloughs and see what needs to be addressed.
Mr. Stigler, you have the ear of the governor. Is that something the governor is willing to look at some point? I understand that, his philosophy is furloughs. But do you think that seeing the damage that's caused to the public by the backlog of cases that are ongoing, is that something that, do you think that he'd be willing to look at? I know that you can't speak for him.
Right. I think the administration is interested in hearing any options that would improve the current situation.
Okay. Only because, the public safety is at risk. Okay. What's been going on the approval of the vendor for the board's diversion programs? There appears to have been approval, then disapproval.
I don't have that information.
It was approved, I think maybe within the last 2 months. I'm not sure the exact date. The contract was awarded to Maximus. There had been bid protests, which extended the time to approve the contract. So we have an audit plan in place. We're going to be working with the boards that are impacted to go over the audit plan and then commence that shortly.
Are they the only company that has this program? Is there some reason we only work with them? Are they the best?
They were the one that met the requirements of the bid and were the lowest responsible bidder. I believe.
Yeah, but being the most responsible bidder when you have 36 times that somebody doesn't come doesn't necessarily mean they're the best. May have been the lowest bidder.
Right.
So that's a concern.
Right. Yeah, I know there are other entities out there. I'm not sure how many, but I could get you that information. Who else was in the process?
And your philosophy is, Mr. Stigler, is that we're going to do better, that we're going to find some remedy?
Absolutely. For two reasons. Number one, we have about 3,000 employees at the Department of Consumer Affairs that are ready for a new system. We just have to give them the system that they can use efficiently. And secondly, failure is just not an option.
So you're going to be the rah-rah guy?
Absolutely.
Okay. All right. Anything else you'd like to talk to us about, that it's not acceptable, it's not something that we really can tolerate, and the legislature is always willing to do a lot of legislation,
right.
But I don't know that doing a lot of legislation, if you think that your departments could do something better.
Well, we are going to need some help, and if I could take just a second and go over some of the summary. What what Laura handed you are the proposals that we're going to make forth going forward. And here is the summary. Right now, the existing enforcement model lacks efficiency. Our new enforcement model is going to establish greater efficiencies. The existing model does not promote accountability. We want to make our boards more accountable. The current enforcement model protects licensees. We want to change that and make the protection of consumers paramount. Right now, it takes an average of over 3 years to finalize an enforcement action. We believe that with our new system, we can get that down to about 12 to 18 months. With regards to accountability, right now accountability is spread over several different agencies. We want to focus that just to the boards and to DCA. We don't have a DCA person right now responsible for monitoring the enforcement programs. We want to establish an enforcement compliance officer. Our case management system, as was talked about earlier, is weak and inefficient and doesn't work really at all. We want to establish a brand new case tracking system that integrates the Attorney General's office work. Our existing enforcement model utilizes sworn DFI investigators almost exclusively. We want to open that up and use non-sworn investigators, paralegals, inspectors, and other staff. It's difficult for our current system to get records from state agencies. We want to incorporate some consequences in our new system to establish stiff penalties for businesses that fail to cooperate. Right now, the process to suspend dangerous licensees is too lengthy. Again, we want to grant the executive officers the authority to suspend a license if the respondent fails to produce documents or participate in an interview. Best practices, our best practices right now, we don't shift between our different boards, and we can do a better job. Under our new model, we're going to formalize identifying best practices and share that between everybody. We want to put consumers first again. Currently, interim licensee suspensions are cumbersome, necessitating court action. Our new model allows for timely suspension of a licensee who has committed a serious violation of the law. Existing diversion programs allow licensees to escape discipline. We need to consider the performance of our diversion programs, and if it requires eliminating them, maybe that's what we should do. Our current system does not inform the public of lesser disciplinary violations made by licensees. Our new system is going to increase transparency by requiring boards to report all disciplinary actions online. And finally, our current model forces lawful licensees to pay for costs associated with enforcement actions. Our new system holds licensee violators responsible for investigative costs. So most of these recommendations are provided in more detail in the documents that were handed to you earlier.
Now, we will still have due process for the accused?
Yes. Yes.
Okay. All right. Did you have any questions?
You'll hear from some today about the vertical enforcement model. What's your thoughts about that? Are you familiar with it enough to comment, or would you like to respond at a later time? You will hear a lot in terms of people think very positively that that model might work better in the long run.
But here's what I think. I think that the basic of vertical enforcement really requires investigators to work closer with the prosecutors, and I'm all for that. Whether we call it vertical, horizontal, or diagonal, it's very important that our investigators work very closely with the prosecutors.
Okay. Thank you very much. Thank you for your time this morning. Thank you. Okay. The next panel is Darrell Walker, Karen Chappelle, Carlos Ramirez, and Ron Dietrich.
She'll start off. She'll do the Karen.
Karen, you have a PowerPoint? I do. Okay. Well, I guess, okay. Oh, it's right here. I've got it.
Good morning. I'm Karen Chappelle, and I'm a Supervising Deputy Attorney General in our office, and been there doing consumer protection for about 20 years, which is what brings me here today to discuss the backlog with the nursing cases and where we should go and how we can break up the logjam and get these cases processed quicker, faster, and better.
Is this the only place you have a log jam? Are there any other places?
This is the place that we've been studying most closely right now, and I would say that we can always do better and prosecute the cases faster. But I think that some of the proposals that are being recommended, like the vertical enforcement model, is something that's not necessary in order for us to accomplish that task. In fact, we have some data to show you that indicates that application of the vertical enforcement model might actually slow the process down. Now, I'm really appearing on behalf of my supervisor, Alfredo Terrazas, and he's not here. He's actually on a well-deserved vacation with his little 5-year-old grandson, but he gave me an awful lot of data to
go ahead and
present, so I'll just go ahead and get started on that. Basically, the licensing section represents a number of, very briefly, these are the typical steps that happen in a licensing disciplinary matter, and I apologize that this presentation takes place over your shoulder.
That's okay, I have it here.
Oh, yeah, okay, very good. And as you can see from...
I'm omnipresent.
Okay. Well, that comes in handy. As you
That's
can
what
see...
my kid said.
Yeah,
Mama, how can you have
eyes in the
eyes?
back of the head. That you need that when you have children, that's for sure. As you can see from this slide, there are a lot of different entities involved with the prosecution or the handling of a disciplinary matter. The intake at the agency, the Attorney General, and then over to the Office of Administrative Hearing. And the part that I want to focus on was that we here have a liaison DAG in place between our office and the agencies. In fact, we represent about 35 different state agencies, and with each of them we have a liaison deputy in our office, and that the liaison concept is meant to function as a conduit between the agency and our office, so that at any time staff can access a member of our office and talk to someone who is intimately familiar with the nuances of that particular agency. Some agencies, like the nursing board, we actually have 2 liaisons, one of whom is present here, Hannah Rose. This is just meant to show that we do have a liaison in place, and we don't have one with the Division of Investigation. We represent many of the DCA agencies, Allied Health, except for the ones that are indicated there. Why an assigned liaison DAG makes sense is because of the high volume of cases and the wide variety of knowledge that is required. There has been reference made in both the reports from CPIL and also your internal report that describes our licensing deputies as generalists. And we would argue that the contrary is true. We would argue that the allied health agencies that we represent actually consume 40% of the caseload for the licensing deputies, and therefore our deputies are highly trained with expertise on each agency's statutory framework, their disciplinary guidelines, and their policy prioritizations, so that no other section in the Attorney General's office, not even within our office, has that type of specialized, highly personal knowledge. And in times like these where there's a high turnover of board staff, this type of relationship in place is very important, because our liaison deputies have a requisite amount of institutional, historical knowledge and memory that many of the staff members do not have. And it creates a integrated learning organization from the staff to the investigator to the prosecutor. And this is very important in terms of processing the cases. I'm having some difficulty with my... Okay, and here's the general statistical data. Now, this chart here is meant to convey, first of all, the broad nature of the cases that we handle for DCA, and here I'm at the slide that's on page 9 in your presentation. And what I want to do to focus here is that the number of registered nursing cases that came to our office in that fiscal year of 05-06 is 611. Now, 2 things to point out here. This particular year came at the end of a 2-year budget augmentation, which followed the 2002 Sunset Review for the board. During that period of time, we had liaison deputies from our office visit the headquarters for the nursing board in Sacramento twice a month, and they were able to get in there and develop strategies and approaches to moving those cases through the system. Many times the nursing staff or the enforcement staff at the nursing board may not feel comfortable with closing a case as it comes in. Madam Chair made reference this morning to some complaints that might be frivolous. Someone calls and says, I had a shot from a nurse and it hurt. Now, is that something that should resources and time be spent to investigate? And we think not. So with the assistance of having a Deputy Attorney General in a liaison capacity paired up with the nursing board staff on an ongoing basis, we think that could get in there and help them to develop policy, protocol, criteria for which kinds of cases you don't need to spend time to investigate, which ones do need to be sent over to DOI, which ones can come directly to us. And that's what this slide was. Now, in the next year, after the budget augmentation, note the sharp decline in the number of cases that came to our office from the nursing board, 375, as opposed to just the year before, where there were 611. Now, that's almost a 40% decrease. Actually, I think it's 39.6. And we attribute that to the fact that there was first of all, the resources were taken away in terms of the budget augmentation, and second of all, there was no liaison deputies that went to the board headquarters to assist them with going through their cases. And in the following fiscal year, 07-08, again, there's a steady rise in the cases, 454, but still nowhere close to, it's still 26% below the number of cases that we received in our office during the 05-06 period of time with the budget. And here is the current fiscal year that ended June the 30th, where you can see 562 cases. So that number is up. There is a steady rise. And while we don't have a liaison deputy that is actually traveling to the board headquarters, what's happening is the board liaisons are working over the telephone with enforcement staff at agency. It's not as intense as the in-person visits. It's more over-the-phone crisis management. It's not what we call strategic planning by design, which is what the way that we like to operate. But nevertheless, the stats are coming up in terms of the number of cases. Now, with respect to the implementation and the extension of vertical enforcement to the Attorney General's office for the licensing section, extending it beyond its application currently to the medical board, it's our position that it's not necessary. The medical board cases, of course, are far more complex than the cases at the nursing board. And right now, if you look at the data, and this data in the blue line graph depicts the data that we get from our internal case management system, ProLaw. And the red line data indicates the information that came in the medical board report that was delivered at their June meeting from an independent source called Integrated Solutions for Business and Government in Sacramento. The timelines and the milestones on comparison from vertical enforcement to enforcement with the Attorney General's office aren't always the same. So what we measured were milestone events that were critically the same. In other words, the length of time between when a case is received in our office to when an accusatory pleading is filed. And you can see the numbers here for the nursing board cases, and we've compared them to the cases that are currently subject to the vertical enforcement model. On this first slide, where you see, let's just take the FY 2008-2009 for the number of days on the nursing cases, and licensing is 111 days, and the number of cases that were processed during that period of time is 562. And so you compare that to the average number of days of 147 subject to the vertical enforcement for 205 cases, far fewer. So as you can see on the bottom chart there, our numbers are trending down in terms of the number of days it's taking us to process our cases. And so we feel that the application of vertical enforcement would hamper that. Now, the next slide is even more dramatic because here, to use Alfredo's term, now we're really comparing apples to apples because now we've taken out of this the physician and surgeon cases for the medical board. Now it's just the allied health cases in HQE that are subject to the vertical enforcement and compare them to the allied health cases for the nursing board. And the medical board cases and their allied health cases would necessarily take priority over the ones if they also subsumed the allied health clients from licensing, including the nursing board. So now look at the dramatic difference. It's still 111 days on ours for the nursing and 562 cases, and then you compare it to 234 days for the allied health cases under vertical enforcement to process only 47 cases. So you see the underlying assumption that applying vertical enforcement to the nursing cases because it would process them faster, quicker, better, that assumption is not borne out by the data. We think it's inaccurate. It's wrong. The final slide that I have with the statistics, we measure the settlement, the time from the opening a matter, an accusatory pleading, to the proposed settlement for those cases that don't go to hearing. And as we know, the high number of these cases do settle, between 70 and 80%. So if you look at the average number of days for the licensing cases, the nursing board cases, it's 183 days, and compared to 449 days for vertical enforcement. So we believe that vertical enforcement adds a layer of entanglement and kind of an over-the-shoulder from the deputy or the prosecutor with the investigator that it's not required with these types of cases, whereas it might be more beneficial with the medical board cases. So looking at the data, it doesn't bear out the underlying assumption that vertical enforcement would make the cases move faster. We believe that the model that we have in place, or could put in place, of a liaison deputy with the Division of Investigation, they have a big backlog and they're not fully staffed. But what we do have in place is a collaborative and a collegial relationship with the current director of the Division of Investigation, Darrell Walker, and my boss, Alfredo Terrazas. They have already met, and the two of them have already identified 2 deputies that they would like to see in place as liaison deputies to the Division of Investigation. This is a model that we see works because, going back to that first slide I showed you, when we did have liaison deputies to go to the offices, they were able to break up those log jams and get in there and process those cases by giving the guidance and the advice to D of I and to the nursing board. And these 2 deputies, one is a former DA that has expertise in training investigators and cold case files, and the other was a public defender who was a research clerk for the Ninth Circuit. And this is a model that we could put into effect within 24 hours. We could send those deputies out there basically tomorrow to start looking at the cases that are stacked up in the queue as a backlog. And with respect to the other recommendations that are outlined in your internal memorandum, with the exception of the vertical enforcement, basically that report adopts at page 28 a lot of the recommendations that were made by Alfredo and the July 27th report to the nursing board.
Okay, since we have to move on,
Okay.
I have to ask you, how often has the AG's office had to stop pursuing cases because the Board of Nursing or another board had insufficient funds to continue with the case?
On the nursing board cases is slide 17, and so
17 cases, 17%?
No, it's slide number 17. For 08-09, we only had to slow down on 2 cases. In 07 and 08, there was only 1 case that we had to slow down on. It trended very high at 05-06 when they ran out of money after that budget augmentation. That is problematic because then those cases get put to the end of the line. But with right now, Alfredo.
So if you had somebody that was committing egregious acts, you would put it at the end of the line? because
No,
you have the
public
money?
safety cases at all times went forward, even if there was no money in the budget. At all times, public safety cases were given the highest priority.
Okay, all right. So can we just move on?
Yeah, and that's the end of my report, and thank you so much for the opportunity.
Okay, Mr. Walker, do you want to go ahead and start?
Yes, Darrell Walker, Acting Chief for the Division of Investigations. The division consists of approximately 78 people total. 55 of them are authorized sworn positions. Of those, we have approximately 38 for field investigators, what I refer to as boots on the ground. Of those 38, we have currently 31 filled at this point. Anticipating filling our remaining vacancies hopefully within the next 2 or 3 months. We have folks in background right now. The division has 7 field offices throughout the state of California. All its investigators are peace officer investigators, and we handle the administrative and criminal investigations for various boards and bureaus throughout the Department of Consumer Affairs. As the years have gone by, the staffing level for the division has declined. We lost one of our field offices a number of years ago down in Alhambra. And on top of that, the caseload has grown. And that
What do
has...
you mean you lost it? It was just you misplaced it?
No, they disbanded the office, and
Okay.
it was gone. And it was before my time, but it existed a number of years ago. So.
Okay.
And so our other offices out of our Los Angeles area have had to pick up the workload that particular office carried at one time. On top of that, as I said, we've had a reduction in staffing levels while we had an increase in workload. To be quite honest, the Division of Investigation has been overrun with work. We cannot keep up the load that's coming through the door. And we've had discussions with various boards on this issue. We strongly agree with the Attorney General's office that we need to establish a case criteria system which each board that would determine what cases truly need to go out and needs the resources of an investigator versus the resources of, say, an enforcement analyst. The Board of Registered Nursing is understaffed. They do need people in those specific classifications. I know Mr. Thornton is going to be talking here now in a few more minutes about the medical board, and I believe he'll be talking about the central complaint unit. I had the privilege of working in that unit at one time when I was with the medical board. I know the benefits of a complaint unit. I know that they can resolve a tremendous amount of cases at that unit without going out to full investigations, and only those that go out to the field truly need the services of an investigator. I believe that's a good model. In addition to that, the Division of Investigations was authorized approximately 2 years ago to develop that model within its own program. It's small right now. We have a total of 3 people. We do have 2 more analysts coming on in January, and we believe we can provide a lot of the services, just a lot of the boards that don't require a full investigation. An example, quality of care cases. These are kind of bread and butter cases for your health, allied health boards out there, and quite often quality of care cases requires obtaining the medical records and reviewing those medical records along with the complaint to make a decision: does this case rise to the level for it to go out for full investigation? Experience has taught me from working in the complaint unit at the medical board that the vast majority of quality care cases don't rise to the level it requires a full investigation, and that they can be resolved at that complaint unit. That current system, if that were put into place, would be a great benefit to the board, to the Division of Investigations, and to the Board of Registered Nursing.
Give me an example of what would not rise to the level.
Say, for example, there's an allegation that the nurse did a procedure incorrectly and caused harm to somebody. What you would want to do is you want to be able to obtain, you receive a complaint from a citizen. You're going to want to look at that complaint. You're going to want to obtain those medical records. In fact, you could even, as the medical board does, request that the complainant respond in writing to the allegation. And then at that point, a medical consultant or a nurse consultant would review the complaint
Ms. Chappelle made a comment about, a nurse gave you a shot and you said, ouch, it hurt, not going to complain. That would never even be there, would it?
Those are the kind of cases we're proposing not come out to the board, to the Division of Investigation.
Okay.
Right now, we need to develop a case criteria system to really determine what comes out to us.
However, if a nurse gave me a shot and hit a vein or nerve
Correct.
where it did something, then that would be different.
Absolutely.
Besides it hurting, it would do some damage. Okay.
That's correct. And that's where having the nurse consultant review the medical records and take a look at that can make it determine whether there is a sufficient evidence at that point to move the case forward versus that case just goes out to the investigator. They have to do all that work and send it to a consultant. It saves staff resources for the Division of Investigations, and I think allows the Board of Registered Nursing to have a more timely response on those kinds of cases and resolving them. But once again, it's there's a staff resource issue, not only with the Division of Investigation, but also the Board of Registered Nursing to handle those kind of issues.
Thank you. So how can we help you? Aside from capturing Schwarzenegger.
I really think, and the Division of Investigation has been working very closely with the enforcement program at the Board of Registered Nursing, where we have several things in place right now trying to resolve our backlog of old cases. And once we resolve those backlogs, which I am convinced we are with the processes we're putting into place, our 365 project, and what we refer to as our intake task force that rolls out on next week with the Board of Registered Nursing, we're going to resolve a lot of our backlog of old cases. But what do you do to prevent that from happening again? And that is where then at that point we really look at developing case criteria to really determine what truly needs to go out to the Division of Investigation and provide the Division and the Board of Registered Nursing the resources they need to prevent that from happening again.
Should we change the system for a more traditional fee-for-service from the boards to you?
That's a very confusing, complex issue with many of the boards. It's the budget, and I'm not going to profess to be a budget expert, but the budget process, there's a fixed amount of money that's established that each board has for DFI's investigative services, and that's set by our budget office, and it's hooked into our 2-year roll forward process. Mm-hmm. So let's say in 1 year the Board of Registered Nursing has a deficit at the end of the year that they spent more than were allotted to the Division of Investigations. Then in that case, they have 2 years in the 2-year roll forward to come up with the funding to make up that difference. More recently, it's been the other way around. The Division of Investigation the last 2 years actually has refunded money to its various boards and bureaus. And the reason being is that when I first came on 22 months ago to the division, we had a 35% vacancy rate of our investigators. And we could not justify expending money on positions when there were no bodies there producing a product.
Okay, so what about a Special Operations Unit? What is that?
Special Operations Unit is a subset of the Division of Investigations. Its funding is separate from the division itself. It handles all the internal affairs investigations for the entire Department of Consumer Affairs.
Cloak and dagger?
They're the men in black, and they handle all the background investigations for our positions at the division. They handle our training needs and so forth. But their primary function is to provide investigative services to DCA executive level for internal affairs, workplace violence issues. They chair the Workplace Violence Committee and so forth.
How many people do you have in that committee?
We have 5 investigators and 1 supervising investigator.
And they're needed?
They have a very heavy workload at all times.
Okay. All right. Thank you.
Good morning, Madam Chairman. Thank you for inviting me to appear before your committee. My name is Carlos Ramirez. I'm with the Attorney General's Office. I am the Senior Assistant for the section of the Health Quality Enforcement within the AG's office. I do want to clarify something, that the views that I express here today are not the views of the department, they're not the views of the Attorney General. They're my views based on 25 years of experience prosecuting healthcare cases. That being clear, I'd like to go back and explain that, remind all of you that the section, the Health Quality Enforcement section, was established in 1991. It is one of the newer sections within the Attorney General's office. Initially, the section was established for the purpose of providing legal services for the medical board, but in the ensuing years, the number of clients that the section is providing services to has expanded to 8 and 9, I believe. 8 of those are listed in your paper, and those include the Osteopathic Medical Board, Acupuncture Board, Board of Podiatric Medicine, Board of Psychology, Hearing Aid Dispensers Bureau, Physical Therapy Board, and Respiratory Care Board, and lately the ENSA. Now, since 1991, we have experience with different enforcement models. We first started with a model that was called the Deputy in the District Office model, which placed a Deputy Attorney General in every one of the 14th Medical Board district offices throughout the state. Okay, Sacramento, we had deputies in Fresno, we have deputies in Tustin, we have deputies throughout wherever there is a medical board office, we have deputies in those offices. And the purpose of us being there was to assist in evaluating the complaints that came to those offices to determine which should be prosecuted, which should be closed, and which should be moved to the front of the line because the licensee or the circumstances presented were such that immediate action needed to be taken. I mean, immediate action, it's not an action that would take 2 or 3 months, an action that would take 2 or 3 weeks at most, perhaps days. Okay. After a comprehensive review that was commissioned by the medical board and was conducted by CPIL, I believe in 2004, I believe 2002, CPIL did a comprehensive review of the enforcement systems, not only of the medical board, but also the Attorney General's office, and recommended that a vertical prosecution model be implemented. It was lately changed to be called vertical enforcement. I think that's more accurate because not every case, not every complaint that comes into the system ends up in the prosecution of a physician. Many of them are closed in Sacramento before they even make their way into the general population of complaints. Generally speaking, and I know that Barb Johnson, who is going to come after me as the executive director, probably has more accurate data than I do. Approximately 75% of the complaints that enter the system get closed in Sacramento. The other 25% get farmed out to the 13th, 14th district offices throughout the state. Once they arrive at that district office, they are immediately assigned to a deputy and an investigator to work hand in hand processing those complaints. Okay? The joint assignment lasts throughout the duration of the enforcement process. Starts at the investigation stage and ends in the prosecution stage. Having had experience with Ditto and other programs, we found that perhaps the most important part of prosecuting a violation of the Medical Practice Act really rests with the investigation, at the investigation stage. If the correct witnesses are not interviewed, if the appropriate records are not included in the investigation file, that prosecution is not going to go very far, and it's going to waste a lot of resources in the process. More than that, it's not going to result in any public protection. So it is a more labor-intensive process. It is a highly interactive process in which We have lead prosecutors now in every district office. We have trial deputies traveling in and out of the offices. We actually make house calls. We don't just sit in our office. We actually go to where the work is, whether it be in Tustin, whether it be in Fresno, whether it be in Rancho Cucamonga, where it is, that's where we are. And that, of course, has, apart from that, the system that we employ is a little bit different because we are there at the district office. We participate in physician interviews. We help investigators draft subpoenas to obtain medical records. We do everything that's necessary to process that investigation as expeditiously as possible, and in a manner that's going to result in a successful prosecution. I believe that, well, I've submitted this to you. If not, I can leave a copy with you, and we can make additional copies. This was the initial vertical prosecution manual, and it is the manual that governs the application, the implementation of vertical prosecution to medical board cases and allied health cases. And in that manual, both the medical board investigators and our deputies commit to certain goals in the processing of complaints. For example, 5 days after the investigation is assigned to an investigator, that investigator must submit an investigation plan for review. If there's a subpoena that's needed and the medical board investigators ask for assistance, we have 10 days within which to provide that assistance, provide input to that subpoena so that we can get the records and the investigation can move forward. After the investigation has been completed, the assigned trial deputy has 5 days within which to accept that investigation so that it moves from the investigation stage to the prosecution stage. Once it's in our office, the goal is to have those accusations filed within 30 days from the time that we receive the accusation. Once the accusation is served and the respondent asks for a hearing, we have a goal of requesting a hearing from the Office of Administrative Hearings of 15 days. Okay. Those timelines vary, and oftentimes for good reasons, but those are our goals. You saw some of the slides that were presented by my colleague, Karen Chappelle, with regards to licensing. And although I did not come this morning to speak to the advantages of one system over the other, what the statistics are, one slide did catch my eye because there were statistics that were taken from our own pro-law system, a case tracking system that the AG's office uses, and compared with the statistics of an outside vendor, outside source, notwithstanding the fact that we, as an office, officially complain about the way the process, those statistics were compiled. But what that did, it basically compared pro-law statistics for licensing with outside statistics for HQE. And one number that kind of like stuck to my mind was the 111 days that, according to pro-law, it takes licensing to file accusations. Using our own also statistics, apples to apples, during calendar year 2008, it's taken us 53 days to file accusations, medical board accusations. And as was indicated by my colleague, the medical board cases as well as the allied cases those cases we handle are complex cases. So at least with regards to the medical board, with regards to the cases that we handle on behalf of the allied health care agencies, our indications show that they are moving along a lot faster, certainly a lot faster than what the outside vendor showed them to be just recently. You have any questions? I know time is of the essence, so if you have any questions, just feel free to interrupt me, and I will try to answer them. There's been some successes in VE. Others we have not been yet that successful yet. For example, over the last 3 years, over the life of the VE program, we have reduced the number of days that it takes to file medical board cases by 38%. These are not our statistics. These were the statistics of the vendor himself. So even under that interpretation, the program is working with regards to the filing of the accusations. Okay? With regards to the timelines of investigations, we have not yet turned the corner there yet, and that could be for many reasons. Okay, we turned the corner in terms of quality of investigations. And we say that because it would not be possible for us to move from investigation to the filing of the accusation if we didn't have a quality investigation before us. Okay. The times to take the matter to hearings have also been reduced. And it's also a tribute to the quality of the investigators. Okay. The timelines, another story. They remain the same, perhaps a little bit longer at the investigation stage, but that could be attributed to many, many factors. One, of course, is the insufficient number of investigators at the medical board level, notwithstanding the medical board's efforts to keep everyone on board. There's obviously people that leave for other positions. They can't help that. So that in itself, is a factor. Okay. The other factors may be that, unlike other agencies, the medical board does not control every aspect of its investigations. For example, they have to hire outside consultants to review the medical records, both in-house and outside experts. Okay. Those timelines can at times be impacted by the current fiscal crisis, can be impacted by other aspects that are not within the control of the medical board. You may have a set of records sent out to a physician for an expert review, and we're talking about hundreds of pages here, okay, not 2 or 3. So that may take a little bit longer than normally we would like. But that is just part of the process that's built into the system, that we're not going to go forward with the case unless we have an expert who's actually reviewed the entire case file and has indicated that, in fact, there are violations of the Medical Practices Act. Okay? So, again, those are factors beyond their control. Okay? But with regards to the medical board and the clients that we serve, so I'm only addressing those. I believe that we've turned the page turned the corner on the filing of the accusations, and we're on our way there with the investigations. Any questions you have, I'd be glad to answer them. If you want me to submit statistics comparing different programs, we can do that. Okay.
Okay. Thank you. Sure.
It appears as if we have a difference of opinion between the licensing section and the health quality enforcement section regarding the vertical enforcement model. The licensing section would rather go back to the old Ditto program, yet you believe the vertical prosecution model is sort of the way we should be.
I'm speaking to the medical board and the clients that HQA services. My colleagues in the licensing section, very good attorneys. They do very good work. I have many friends there, and they're entitled. Obviously, they speak through Karen today.
We're not advocating a return to the Ditto program. It's the use of it's an enhanced liaison program. Right now, we already have liaison deputies. The Ditto program put deputies in district offices, all 12 for the medical board statewide. We're just talking about sending deputies to the headquarters in Sacramento, and this is just for the short term, just to get rid of the logjam and stop it from reforming, and to perform the same service with the Division of Investigation, where the backlog is right now. We're not talking about sending. The Ditto program sent deputies out to the district offices on a twice-a-week basis. They basically maintained an office there. That's not the type of entanglement that we're suggesting, nor do we think it's necessary at this point.
thought I saw in your recommendations was that you'd like to reinstitute the Ditto program.
Oh, in Alfredo's recommendations?
Yes.
Well, I think that he may have used that terminology, but in terms of the model that we are proposing is the one that I'm suggesting as the enhanced liaison. Okay.
Good morning.
Good morning.
Thank you for inviting me.
I don't think it's on. Okay, it is on.
All right, thank you for inviting me. My name is Ron Diedrich. I'm the Director and Chief Judge for the Office of Administrative Hearings. In an attempt to be respectful of everyone's time, I'll try to keep my comments short and only in 3 areas. I'm going to provide you some statistical data that you may find useful that you haven't heard already. I'd like to clarify some issues about administrative law judge training. And I have 2 recommendations to consider that haven't been made so far and could be done within the current system. First, I'd like to note that since 2002, the Office of Administrative Hearings has completed over 78,000 cases for over its 1,000 client agencies. Of those 78,000, approximately 60% were completed within 90 days. Over 85% were completed within 180 days. Over 97% were completed within 1 year. And less than 3% took longer than 1 year from the time it came in the door at the Office of Administrative Hearings and until the time it went out the door at the Office of Administrative Hearings. The average length, and this is just an average, the average length of time that a case is open at the Office of Administrative Hearings is 112 days. For the RN Board, the most recent statistics show that 82% of their cases are completed at the Office of Administrative Hearings within 180 days or less. 95.5% of their cases are completed at the Office of Administrative Hearings within 1 year or less. 4.5% of their cases take more than a year at the Office of Administrative Hearings. The average length of time for their cases at the Office of Administrative Hearings is 127 days. That is, once they come in the door at the Office of Administrative Hearings, once they go out the door at the Office of Administrative Hearings. Now, on the clarification about the administrative law judges, the Office of Administrative Hearings does have a medical board panel of administrative law judges. Currently, there's 13 judges on that panel statewide, but medical board cases are not the only cases they hear. When they're not hearing medical board cases, they're hearing cases for any one of those other 1,000 client agencies. Now, the other administrative law judges in our general jurisdiction division also receive all the training, all the medical training that those members on the medical board panel receive. So to the extent it looks like from the staff report that the medical board judges only hear medical board cases, I'd like to clarify that. And to the extent that it appears that the other judges don't receive the same training, I'd also like to clarify that. They do, in fact, receive all the same training to be able to hear medical board cases. And at times, because cases don't come in a straight line, they come in waves. At times when there are more cases than the 13 judges can handle, we do in fact use the other trained judges to hear medical board cases so that those cases don't sit and pile up while we're waiting for judges. And conversely, when we don't have a lot of cases to keep them busy, they hear cases for the other clients, so they're not sitting around waiting for the cases to come in. And now in the third area, the suggestions. There's been lots of very good systemic suggestions made that the Office of Administrative Hearings think are worthy of investigation, taking a look at and discussion. But we have 2 suggestions that we are currently doing for other client agencies. They appear to be successful, and they could be implemented now should within the existing framework. The first suggestion I would like to make is that boards, should they choose to, with help of the Attorney General's office, could engage in much earlier and much more aggressive alternate dispute resolution, basically settlements. Our settlement rate is very high. Depending on the client agency, it's either between 60% to over 90%. If there's a firm commitment of the resources and the ability to take those cases early on into an alternate dispute resolution form, whether it's settlement or mediations, I would hazard a guess that they would have the similar kinds of successes early on in the process. The second suggestion I would like to make, and that is that there be a greater use of essentially our short cause calendar. That is stacking cases, short cases on one day instead of just scheduling one case for one day. There are many cases for a number of our client agencies that take far less than one day to complete, and yet we have the judge and we have the courtroom for the entire day. And for short cause matters, we can move cases through much more quickly there, and do. Now, let me be clear, not every case is amenable to a short cause matter. Only certain cases are, but again, it's a commitment that has to be made by both the boards and by the Attorney General's office to put resources into that. And I know they have limited resources, so for them it's a judgment call as to where to put the resources. And hopefully those were succinct enough, and I was respectful of your time.
Okay. I've got a question. Everybody here on the panel said how quickly you do the cases, how quickly everything goes by. We had a hearing on the medical board, and what I got out of that was that it takes a really long time to finish a case. The LA Times just did an article that says it takes a really long time to complete a case. So you're either telling me something or somebody's telling me something differently. So you're either not doing as well as you're all saying you're doing, or the LA Times is saying they lied.
All right. Well, again,
one or the other.
I think it's a little of both, frankly. But I would point out when you have 78,000 cases and 3% take more than a year, that's a significant hard number. And what you see are one or two or three or a handful of cases that get a lot of the press, and the other 78,000 move through the system fine. In addition, candidly, there are cases that do fall through the cracks. In that regard, we have beefed up our case management system and our case tracking system and our case reporting system over the last 2 years to try to catch those cases that don't fall through the cracks. And frankly, a number of the older cases are because of matters completely outside of the control of the Office of Administrative Hearings or the Attorney General's office or the attorneys for the respondents. Those primarily being the attorneys are unavailable, the expert witnesses are unavailable on the hearing date, respondents who have criminal cases, their criminal matters are still pending. There was respondents who are incarcerated. Frankly, there's a number of cases where the accusations, that is the pleading to take away the license, are amended late in the process. And of course, the party on the other side gets an opportunity then to respond to the amendments. We've had illnesses, as noted by the graphic that's still up there. In certain years, there's been an issue of boards running out of money, and therefore the cases that come over start to slow down. And I could go on. I have a whole list. Frankly, we pulled all of the cases that were more than a year old, pulled all the files, looked for them, looked for all of the reasons why they were more than a year old. So there is a significant hard number of cases. There is room for improvement, but overall, each year, our statistics through case management tend to show that things are getting better overall for the great bulk of the cases.
Yeah, there may be other reasons. Well, there may be some other reasons. For example, in calendar year 2008, Medical Board filed 21 ISOs. These were instances in which the Medical Board, through its actions, suspended the practice of a physician. Okay? So it took the board an average of 19 days to do that, a median of 10 days. So from the initiation of the investigation to the time that the physician was suspended, it took a median of 10 days. Okay. Now, it may be that a physician is criminally prosecuted. Okay. So in those instances, he may not have an interest in pursuing the administrative matter right away. Okay. Nor will we have an interest in pursuing him any further because he's suspended from the practice of medicine. Mm-hmm. Now he's in the criminal justice system, and that's going to take some time to work itself through the system. Okay. In other instances, you may have a medical board case that starts on time, within a reasonable period of time, and during the trial, something happens and this has to be additional trial days set, okay? So then those dates are then set further into the future. Generally speaking, it takes a little bit longer to litigate medical board cases at the Office of Administrative Hearings than any other case that I've litigated. It's just the nature of the practice. On the average, you'd expect 10 days plus hundreds, if not thousands, of pages. Okay, so consequently, I would assume that it would take Ron's shop also a little bit longer to process those cases.
Okay. Just as an aside, I noticed that on all of your slides that the contractor boards had a lot of complaints and stuff. This is a personal note. Wouldn't fingerprinting the contractor boards work really well?
Yes, it really did. The Full Employment
I'm
Act.
just wondering, because I had a bill that died in public safety where contracted because the contractor boards came unglued because we asked that they be fingerprinted.
Oh, well.
That was just my personal aside.
Wow.
Okay.
All right.
Okay. The next panel, thank you very much.
Thank you.
Thank you very much. Now, I'm going to have to... Okay, somebody's got a phone.
I turned this off.
Okay. The next panel is a recommendation for streamlining the process. If they could come forward. Now, I'm going to now be a little judicious here and start moving everybody a little bit faster because I've only got till 12 o'clock here. So come on forward. I'm sorry, I just did a little...
We are happy to cooperate.
Good morning.
Good morning.
Good morning,
Good to
Madam
see
Chair.
you all again.
It's a pleasure.
Okay, so go ahead and start.
Good morning, Madam Chair. My name is Julie D'Angelo Felmuth. I'm the Administrative Director of the Center for Public Interest Law at the University of San Diego School of Law, which for 30 years has been monitoring and evaluating California occupational licensing boards. With me today is Tom Papageorge. He is the head deputy district attorney of the Consumer Protection Division at the LADA's office. From 2001 to 2005, Tom and I worked together on two-year enforcement monitor projects, one at a non-healthcare board, the Contractor State License Board, and the other at the Medical Board of California. We evaluated every step of both enforcement programs and also the diversion program at the Medical Board. We identified flaws, quantified delays, and suggested reforms to speed up those programs and enable them to protect consumers from unqualified contractors and physicians. Also here today is Dave Thornton, who recently retired from a long career at the Medical Board. Among other things, he served as that board's enforcement chief and also as its executive director, and he was the executive director at the Medical Board when Tom and I served as the enforcement monitor. We're here to share with you our observations and recommendations as you seek to overhaul the enforcement and diversion programs of the Board of Registered Nursing and other Department of Consumer Affairs healthcare boards. I should say that the comments I'm about to make are those of the Center for Public Interest Law only and not of these two gentlemen. The governor has recently stated the enforcement and backlog time found at these boards is absolutely unacceptable. It is clear that the current system is broken and that the entire enforcement process across all of the boards must be reformed. I couldn't agree more. 20 years ago in 1989, the Medical Board's enforcement program was structured almost exactly like the programs at the boards you're examining today. 20 years ago, in April of 1989, my organization published a report entitled Physician Discipline in California, a Code Blue Emergency. This report was not rocket science. We simply described the Medical Board's enforcement program, which at that time was slow and fragmented and under-resourced and lacked authority. We publicized the statistics of the board's enforcement program, which were so pathetic they spoke for themselves. We called for a complete overhaul of the program, and that overhaul was not limited to the Medical Board. We also called for structural changes to the board's other partners in the enforcement process, the Attorney General's Office, the Office of Administrative Hearings, the board itself, and also the courts, which review Medical Board disciplinary decisions. In 1989, we sponsored a bill that contained all of the elements of that overhaul. That bill was killed in about 20 minutes. However, we came back with a watered-down bill in 1990, and we got some major changes enacted, including the creation of the Health Quality Enforcement Section in the Attorney General's office, and the creation of the Medical Quality Hearing Panel in the Office of Administrative Hearings. These are reforms that allow prosecutors and judges to specialize in healthcare discipline cases. And we came back in 1993, 1995, 1997, 2002, 2005, and 2006. Code Blue has now spawned 7 separate bills that have collectively made many, many changes to the Medical Board's enforcement program. We're not saying that the Med Board's enforcement program is perfect. Far from it. Its case processing times are still too long to be acceptable. It still has significant problems, but we believe that part of those problems endure because not all of the elements of that comprehensive reform that we called for in 1989 have been implemented. But it is the agency that you, the legislature, have focused on. It is the agency that, through 7 separate bills over 2 decades, has moved the farthest in the past 20 years toward that complete overhaul. And its case processing times are about 1/2 of those of the Board of Registered Nursing, according to the Los Angeles Times. Regrettably, many of the statutory changes that you, the legislature, have made to the Medical Board's enforcement program have not been replicated at other DCA boards that also regulate healthcare professionals who can kill people if they are unqualified, reckless, negligent, or impaired. There is no good reason for that. And now is the time to extend many of those reforms that have worked at the Medical Board to all the other DCA healthcare boards. Your staff has done a terrific job on your background paper. It is excellent. It sets forth our laundry list of precedents that have worked at the Medical Board and that we think should be replicated to other healthcare boards, including mandatory reporting requirements and other mechanisms, including a ban on the use of regulatory gag clauses in civil settlement agreements that enable the Medical Board to better detect problem physicians. It also highlights public disclosure statutes that require the Medical Board to post on its internet website numerous categories of information that most other boards do not disclose. Prior disciplinary actions, either by the California Board or other jurisdictions. Pending accusations, and the Medical Board posts those in full. Criminal convictions. Civil malpractice judgments and arbitration awards in any amount, and civil settlements over $30,000 where there are more than 3 in a 10-year period, and hospital disciplinary actions where a physician's privileges are terminated. All of that is posted on the Medical Board's website. And your background paper also discusses our ideas on how to overhaul these diversion programs that purport to monitor substance-abusing licensees. These programs must be refashioned into zero-tolerance programs that aggressively and demonstrably monitor substance-abusing licensees. And if that's not possible, as it was not possible at the Medical Board, those programs must be abolished in favor of a transparent system that suspends the license of a substance-abusing licensee until that person can affirmatively demonstrate sobriety and safe, competent practice. And I'd just like to make one comment on BRN's presentation earlier this morning. They told you that they have a new policy wherein they inactivate a license. They put the license on inactive status once a nurse goes into the diversion program. That change was made about 10 days ago, without the benefit of any legislation passed by this legislature or any regulation adopted by the Board of Registered Nursing. It is simply a policy change. And this points up the fact that nothing of any significance appears in any diversion program statutes or regulations. That needs to change if those programs are going to continue. BRN changed its policy 10 days ago. There's nothing that prevents it from changing it right back 10 days from now. Anyway, I can't spend a lot of time on those things. Those are all in your background paper. I also don't have a lot of time to spend on another issue that is of great importance, and that is the need for this legislature to exercise more oversight than it has over these boards by reinstituting the sunset review process, which has been suspended for the past 3 or 4 years. Sunset review should be reinstated, and it should be properly resourced. And to assist sunset review, we believe that the Medical Board's annual report requirement in Business and Professions Code Section 2313, a very simple requirement that's been in place since 1991 at the Medical Board, should be required of all DCA boards. An annual report requirement that documents not only the number of cases flowing through enforcement systems, but how long it takes at each step to assist your staff in conducting sunset review. Instead, I'd like to spend my time on 2 issues that I believe are at the heart of the problems that beset the enforcement programs at these boards. First, adequate resources for enforcement, And secondly, how to overhaul the investigative and prosecution components of the enforcement process. First, these boards need more resources to support adequate enforcement staffing. The enforcement process is expensive. It is funded not from the general fund, but from licensing fees that are paid by licensees. And oftentimes, those fees are passed on to us consumers in the form of higher prices for those services. The licensing fees of most DCA healthcare boards have simply not kept up with inflation, and they have not provided adequate enforcement staffing at these boards or at their partner agencies in the enforcement process. The lack of enforcement funding or restrictions on the use of that funding causes many DCA healthcare boards, as you have heard earlier today, to direct the Division of Investigation and the AG's office to simply stop working on their cases in March of April, fiscal year after fiscal year, causing months-long delays, risking the loss of witnesses, and potentially resulting in a board's inability to take any action on a case because it runs the statute of limitations. Many of these boards lost 15 to 20% or more of their enforcement staffing starting in October 2001 with Governor Davis's hiring freeze. That freeze was not lifted until June of 2004. And many boards have not reinstated those lost enforcement positions, despite the fact that the number of licensees has increased at most boards and the number of complaints coming in has increased at most boards. It is very clear from the LA Times ProPublica reports that these boards need significantly more enforcement funding in order to afford more staffing at all levels and at each step of the enforcement process. And that funding must come from increased license renewal fees. And I'm not talking about simply more warm bodies. For 20 years, we have stressed the importance of specialization and training, which will ensure that folks at each step of the enforcement process are fully qualified to handle these cases in a competent manner. These boards need more complaint intake personnel, which are employed by the boards themselves. These folks need to be properly trained. There must be enough of them so that they do not have to handle caseloads of 500 each. And if there is a critical mass of complaints, as there is at the Medical Board and the Board of Registered Nursing, they should be trained to specialize in handling a particular type of matter quickly and competently, such as a criminal conviction matter, or a quality of care case, or a substance abuse case. These boards need more investigators. Whether they are housed at the department or the boards or at the Attorney General's office, they need more investigators. Investigators who investigate healthcare cases, which are by definition complex, should be permitted to specialize in healthcare cases because they are very different from a case against a geologist or an accountant. The common denominator here across all the healthcare boards is that each board, to prove a violation, often must obtain and produce medical records that are privileged. To do that, they need statutory authorization to collect those records, and they need penalties for those who do not comply with lawful requests for those records. Both of those are in place at the medical board. They're not in place at most of your other healthcare boards. And those investigators need special training in how to procure those medical records and what to do with them, how to analyze them once they get them. Your boards need more prosecutors in the Attorney General's office. And again, we believe these prosecutors should be able to specialize in healthcare cases. As you have heard, the AG's office has a health quality enforcement section, but it does not serve all the major healthcare boards. And there really is no good reason for that. We envision a restructuring of the two major prosecution teams within the AG's office so that HQE handles all the major healthcare board clients and licensing section handles enforcement matters for other DCA boards, enabling both sections to effectively specialize. These boards need more probation staff. Again, wherever they are housed. Could be at the board, could be within the department, could be within the AG's office in a strike force fashion. Probation staff are needed to aggressively police and act on probation violations in a zero-tolerance mode. And finally, these boards need more diversion staff to the extent these programs are allowed to exist. In 1989, when we put out our Code Blue report, doctors were paying $145 per year. Today, 20 years later, they pay almost triple that, about $440 a year. That's the level of the fee increase that BRN and other healthcare boards that have not increased their licensing fees for 18 years and their licensees should expect and, in fact, demand in order to support a restructured enforcement program that will protect patients. But that's not all that must be done. Simply collecting more money by each board is not going to cut it. The legislature and the administration must authorize these boards to spend those increased funds on an enhanced, restructured enforcement system. Obviously, we are not saying we should throw more money at a bad system. We're talking about overhauling the whole system. In this vein, we support two other reforms. First, a portion of the enhanced licensing fees must be earmarked toward a decent complaint tracking system at the Department of Consumer Affairs. As your background paper describes, the current system has been literally obsolete for over a decade, requiring each individual board to purchase or create its own software programs in order to capture the enforcement data that they need. This starve the beast mentality toward basic government infrastructure needs must end. Second, we support significant relaxation, if not outright exemption, of special fund healthcare boards, in particular their enforcement programs, from the required furloughs and the contracting restrictions and the budget cuts that currently apply to all state agencies no matter how they are funded, and that have crippled these enforcement programs. As an example, just 2 weeks ago, the medical board reported that it is losing almost 4,300 investigative hours every month due to 3 furlough days per month. The application of these kinds of restrictions to enforcement programs at special fund agencies does not save a penny for the general fund. They simply deprive special fund agencies of the ability to use their own funds for the exact purpose for which those funds are intended. And they jeopardize patient safety because they have directly led to all of these delays that have been identified. But now we come to the heart of the problem: the investigation and the prosecution of disciplinary matters. I'm going to try to describe quickly how the enforcement process works at these boards, with an emphasis on the investigation and prosecution steps, because they consume the lion's share of this very, very long enforcement process. And then I'm going to turn it over to Mr. Papageorge and Mr. Thornton, who will describe a much more efficient structural model for investigations and prosecutions that has been put in place in part at the medical board, and that, if fully implemented, will cure what ails the enforcement programs of these boards. With the exception of the medical board, these boards employ what is called the handoff model, which is fragmented, inefficient, and creates many opportunities for cases to fall through the cracks. Each board individually receives and screens complaints, and then attempts to track them on a vastly inadequate computer system. If a complaint is serious enough to merit formal investigation, it is handed off,
This microphone here.
to a generalist investigator from the Division of Investigation, a different agency over whom the board has no control. That investigator, who has limited ability to specialize in any particular kind of complaint, who lacks legal guidance as to the elements of the offense and how to obtain evidence of those elements, and who has a caseload of 100 cases, attempts to investigate the case, pulls together the investigatory file, and hands it back to the agency. And that alone takes 1.5 to 2 years. Where it, which is now a fully investigated case, then sits on some analyst's desk for 3 months because they are overburdened and they lack a decent computer system to help them track these cases and alert them to the fact that this fully investigated case is back on my desk now. Now, if that investigator needs medical records in order to prove a case, they are out of luck, because most boards lack a medical records procurement statute that allows them to request records within 15 days and get them, and impose penalties on physicians or healthcare facilities that refuse to respond and to comply with lawful requests for medical records. Eventually, that board analyst will review the investigatory file and will decide whether there is evidence of a violation. If so, the file is handed off to a generalist prosecutor from the licensing section of the Attorney General's office, a third separate agency over whom the board has no control. That prosecutor, who also has limited ability to specialize in any given area, who has had no role in designing that investigation or reviewing the evidence as it has come in over the long 1.5 to 2 year period, and who has no easy access to follow-up investigative assistance, now has to learn the case, draft and file the accusation, and, absent a settlement, try the case in front of an administrative law judge from a fourth separate agency over whom the board has no control. The ALJ presides over the hearing, writes a proposed decision, which is then reviewed by a bunch of political appointees, board members who were not at the hearing, have no access to the record or the evidence, and who meet once every 3 months, if they have a quorum. After the board makes a decision, that decision is then subject to court review. 3 steps: Superior Court, Appellate Court, potentially a discretionary petition for review to the California Supreme Court. It's a pretty nutty process, and it takes years, and it is, on its face, inconsistent with the paramount priority of these boards, which is protection of the public. Turning back to the investigation and prosecution component of this process, this fragmented handoff method has been abandoned at every other law enforcement agency at every level, federal, state, local, that handles complex matters. It has been abandoned at the medical board. As you've heard, at the medical board, the handoff method has been replaced by a more streamlined method called vertical enforcement, VE, where investigators and prosecutors work together in teams. They work together from the day a matter is referred for investigation, and they work together for the life of the matter. Both of them are involved in designing the investigation, and the prosecutor reviews the evidence as it comes in. If evidence that is needed to sustain the board's burden of proof is not surfacing, the prosecutor can much more quickly direct the closure of that case and move on to other cases where the burden of proof can be sustained. Because the medical board has more adequately resourced its enforcement program, and because it and its enforcement partners are using VE, it is making progress toward lowering its case cycle times. You heard Mr. Ramirez say there are higher quality investigations. The accusation filing time by the AG's office is down by 38% because of the higher quality investigations. However, VE has not been fully implemented at the medical board in a very key way. VE works best when investigators and prosecutors work together at the same agency, in the same office, using the same computer system, and able to easily communicate with each other. For 20 years, we have called for a transfer of the medical board's investigator into HQE, so prosecutors and investigators can work together in a vertical enforcement team. And for 20 years, government has resisted that very common sense reform. The transfer has never occurred. Everything short of it has been tried. You've heard about them today. The Ditto program, the Enhanced Liaison DAG program. Everything short of it has been tried. Nothing that has been tried has worked. And I would point out to you that all these delays that you just read about in the LA Times have taken place under the Ditto and Enhanced DAG, Liaison DAG program. This is the fundamental structural reform that we urge you to consider and make right now. The proper resourcing and professionalization and specialization of healthcare investigators and prosecutors in vertical enforcement teams based in the AG's office but serving DCA healthcare boards. Unless you have questions, I'd like to turn it over to Mr. Papageorge and Mr. Thornton so that they can better explain the advantages of VE.
May I, Madam Chair? Madam Chair, members, I'm Tom Papageorge with the LADA's office. I've been in charge of consumer protection enforcement in the LADA's office for the past 25 years, and I've worked hundreds of complex white-collar crime cases of the very kind we're talking about. I was also the enforcement monitor for the Contractors Board and assisted Julie in that job at the Med Board. I'm going to take a very brief moment or two, Madam Chair, and then encourage any questions you have on the issue that the committee has asked me to address, which is this larger question of vertical enforcement. And I'm going to, if I can, conduct what I'd like to call a reality check. I think we've thrown around a lot of terms about this, and I think it's indeed a lot more common sense and simple in a way than Ms. Chappelle's presentation suggested, and then some of the other comments you've heard. We are talking, we use the term vertical enforcement or vertical prosecution, about a very common sense idea that we've attached a traditional prosecutorial fancy term to, and that can be summarized in one word, Madam Chair. That's teamwork. Teamwork between an attorney and an investigator, which is the model used in every private case that's litigated in this country. Every private plaintiff's lawyer, private defense counsel, PD, DAs in most cases, has an investigator and an attorney who work together from day one to plan the investigation of the case, to jointly bring their two kinds of special skills to the mix, and to do a better and more efficient job. every major federal agency, and I'm a former regional director of the Federal Trade Commission, the Environmental Protection Agency, the FTC, the Department of Justice, the Securities Exchange Commission, the NLRB, every DA's office in California, starting in 1954 with the LA DA's office, every city attorney's office in a major city in this state, all of them have rejected the handoff model. Think of the handoff model as a football game where the quarterback insists on not telling the wide receivers or the running backs what the play is, but we'll go out and try to do our best. That's essentially the problem here. You've got to work together as a team, and there's really nothing more complex than that about it. The advantages of vertical enforcement, and this is from my third of a century of experience, are manifold. Bringing the team together early means you coordinate, you work together. You each have expertise that's valuable. It means you put a plan together instead of investigating the same case 3 and 4 times, which is what happens in the handoff model. You have improved quality and, yes, improved speed. Now, we heard from a good friend and a longtime colleague of mine, Karen Chappell, and the licensing law section does terrific work. This is not an attack on any individual or the integrity of that good organization. But in a very real sense, Ms. Chappell's statistics, we're absolutely comparing apples and oranges. Those are different kinds of cases. They are from allied health organizations that often have to stop in March or April. They don't involve expert witness and other kinds of issues. That's not the statistic you should look to compare vertical enforcement with the old handoff, outdated model that's been rejected by everyone else. No, listen more carefully to my colleague, Carlos Ramirez. Carlos has been doing this work in both systems for 25 years, told you that once the Med Board implemented vertical enforcement, 38% reduction in time to accusation, increases in quality in those difficult and complex cases, and on the way to cutting in half or more the overall elapsed time of Med Board cases. And that's without fully implementing VE, which will take another couple of years to be accomplished there. No, in short, what we're talking about is getting attorneys and investigators to work together early and throughout the life of a case. I know of no white-collar crime prosecutor or defense counsel that wants to go back to a system that was outmoded after the Second World War, of the quarterback not telling the running back what the play is. Now, there are different ways to implement it, and perhaps it has to be implemented in slightly different contexts and slightly different ways. But the basic notion that working together as a team from the beginning of a case to its completion is accepted by virtually everyone that does this kind of work. It will be faster, 38% improvement already at the Med Board. It will be better, and it is clearly the wave of the future in white-collar crime and administrative enforcement. And I'll be glad to answer any questions that you have, Madam Chair. Or my colleague, Dave Thornton, will talk about the critical issues of keeping, training, and recruiting good investigators.
Madam Chair, thank you. My name is Dave Thornton. I'm here to talk to you about my 32 years of experience at the Medical Board, and I want to throw in a disclaimer. I'm not here representing the Medical Board nor speaking for the Board because I retired about 2 years ago from the Board, so I'm not here in that capacity. I'm here with you to share my experience working in both models, both the model working at the Division of Investigation, where I began working Medical Board cases along with the other cases that have been described, and when the transfer of investigators occurred where the Medical Board hired its own investigators, and how that system did improve dramatically over what we had before, where one day I would be working a case involving a nurse or some other type of a contractor, and the next day I'd be working a Medical Board case. I think it's important to note that really a milestone for the Medical Board occurred in 1990 and 1991, and that was, number one, with the creation of the Central Complaint Unit, where we were able to screen out approximately 70% of the cases that were going to the field for investigation. Prior to the complaint unit being instituted, we had a system where each of our field offices would take take complaints in and triage those complaints and then decide which ones were investigated or not. And as you can imagine, at the time we had 8 different field offices, so there were 8 different ways of doing things. The second, I think, major milestone was the creation of the Health Quality Enforcement section, where we had deputies working cases strictly for the medical board and some of its allied health clients that the medical board actually did the investigations for. The Ditto program, I helped, worked under that program. And then I became chief of enforcement in 2000. I worked with Senator Figueroa on SB 1950. That bill and some changes that we made at the medical board at the time helped to further enhance, I think, the medical board's triage of complaints. The central complaint system was divided into 2 different units. We had a unit that handled just quality of care cases, and we also had a unit that would handle professional conduct cases, illegal advertising or some other type of conduct unrelated to patient care. SB 1950 also authorized the creation of an enforcement monitor, Ms. Felmuth and Mr. Papageorge, whom I worked with for the next 2 years, both as the chief of enforcement and then after that as the executive director. The result of that enforcement monitor project were 55 recommendations for improving the enforcement program. And I believe that Julie and Tom would agree that the number 1 recommendation was the implementation of vertical enforcement for medical board cases. And all of those recommendations are the recommendations that couldn't be carried out by any other method were included in SB 239. That was also by Senator Figueroa. The unfortunate part of this is that even though the bill started out with the transfer of investigators, it ultimately ended up in a compromise where the investigative staff was not transferred. And I can tell you that we knew that this was going to create a multitude of problems. Number 1, you don't have the co-location of investigators, and that has continued until co-location of investigators and prosecutors, which is critical, I believe, to building teamwork, building a camaraderie amongst the investigators and the prosecutors. Because, frankly, you put a bunch of investigators and lawyers together, and they don't blend too well to begin with. But if you have them in different offices, it's not going to work all that great to begin with. The second problem was the way the statute was written. It created somewhat of a power struggle between the Attorney General's office and the medical board. I think that this has been resolved to some extent, but it still exists because the authority for investigations rests with the Attorney General's office, but the Attorney General doesn't have the investigators to do it. So on the medical board side, you have the investigators, and therein lies a big part of the problem. So we fought to have it fully implemented with the transfer of investigators to the Department of Justice, but we're yet to accomplish that. Now, a couple of things I think are important for you to note that impact some of the statistics that you've heard today. Number one is in 2002 and 2003, during the sweep of positions, the medical board lost 45 positions, and 29 of those positions were enforcement positions. I believe 19 were field investigators. That's number one. Then the other point was the failure to fully implement the. I'm sorry. The other point is that when you lose investigative staff, and I don't think this was addressed by Darrell Walker, but I think it's important to note. When you lose an investigator, sure, you're able to replace that individual 2 months, 3 months down the road, your hiring process. It takes 2 years for an investigator to come up to speed on a medical board investigation. And I'm sure the same is true of Darrell's staff. During that time, every time you lose an investigator, if you lose 19, you've got 25, 35, 100 cases to reassign to other investigators. When you have investigators retiring or leaving, which is typical of the medical board staff, leaving for higher paying jobs in departments such as the Department of Justice, those cases have to be reassigned. That adds to case aging. We were at the medical board in 2001, average investigation time was 198 days. I believe it's well over 300 days now. All of these factors have added to that. I know of cases that have been reassigned 3-4 times to different investigators. Each time, that investigator has to relearn the case. So I think it's important to highlight that. One of the things I think was mentioned in the report is the use of non-sworn staff for certain investigations, and I think that that's probably a very good idea. I think you noted on the agenda that I'm currently have a summer job with the Athletic Commission. I don't know why.
Versatile guy, you, Dave. You just do it all.
But as part of that, we have investigations that need to be done, and many of those investigations can be done without the use of sworn staff by the Division of Investigation. In one investigation, I hired a retired medical board investigator to do that for me, and this works out very well. I think the use of non-sworn staff is probably a good idea. It's a very economical idea, and it's one that I think the boards could utilize. With that, I know the time's running short, and I'll cut my remarks.
Thank you very much. Thank you.
I think Dave might be able to talk about cost implications in terms of if you go to vertical prosecution where it's more expensive or cheaper.
Go ahead and ask it.
Dave, could you tell me, in terms of cost, to use the vertical prosecution versus the current system? More expensive, or?
No, I don't believe it is. The medical board, when I left, it had a $51 million a year budget. About $39 million of that was enforcement, including the Attorney General's office. We did a cost analysis in 2005 in anticipation of the investigators moving over, and we actually found that in the long run, not the short term, because there are training costs, but in the long run, the cost would actually be cheaper for the medical board to do that. And I've also heard some of the reasons expressed for not moving the investigators to the AG's office is lack of control over the investigations. And my response is, I'm not sure you need to control the investigation once it's in the hands of the chief law enforcement officer in the state. And secondly, you do control investigations to some extent because you pay for those investigations at the Attorney General's office, as well as you pay for the time of the Deputy Attorney Generals.
And Madam Chair, Mr. Gage, may I just add to that very briefly. Our experience in the LADA's office, which has more than 1,000 prosecutors and more than 300 full-time investigators, and the reason that we've created now 19 vertical enforcement units where we had none in 1954 is absolutely cost-based and efficient in addition to speed and quality. Pull a team together, they know one another, they train one another, they know what is needed. It is a vastly more efficient way of doing things than a pool system where you pull somebody in for one interview and maybe have to redo that interview again next month. So in our experience in the nation's largest prosecutor's office, vertical enforcement is more cost efficient, Mr. Gage.
Thank you. Thank you very much for your time. Thank you. Now, the next ones are the best practices, and so if you'll come up, Barbara Johnston, Paul Riches, Teresa Bello-Jones, and Richard DeCure. Now, what you'll do, don't read anything for me. Sit down. Don't read anything for me. Just tell me what are the best practices and the diversion programs for the health-related boards. Wait. I know you all have good statements, but don't do that. Just tell me what your best practices are. Yeah, and then just submit your paperwork for me, please.
Oh, in fact, Linda, Linda, did you bring the paperwork?
That's okay. Good.
Okay. I'm Barb Johnston, Executive Director for the Medical Board of California. First of all, thank you very much for inviting me to speak to this committee. This is going to be hard because I practice with my notes, but in essence, what my notes speak to is that the Medical Board of California has been through decades of audits and reviews, good audits, with great recommendations that have been fully implemented to this point to the best of our ability, constrained by things like losing staff, as Dave Thornton has mentioned, and some of the issues that Julie brought forward. But more recently, our current VE program was a full report was provided to this committee and to the legislature that really described what's going on now and what we've been living with as things have evolved over the last 2 years. In that report, there was a set of 8 specific recommendations that our board at its July 24th public meeting fully accepted and has asked the staff to move forward on implementing, and we are currently doing that. I think one of the things that was really important that has happened over the last year or so, though, that keeps coming up a lot in the discussions of this entire hearing, though, is the communication infrastructure. We have all been working with a very outdated, untenable computer system that actually programmers are not even taught in colleges how to fix if it's broken. So one of the things that we've been working hard at is replacing that system. At the medical board, we have been working with the department, agency, and the state office of the CIO to completely replace that system. In fact, we brought a little printout that we're using because we are moving forward, and we hope that you will support our BCPs. That project is gotten to the point where we have a project team, and I think that will make a huge difference, not just on case management and tracking, but it also seeks to resolve one of the biggest barriers on the VE program that we're doing that I think is moving forward, that our board believes is progressing well, and that's the communication enhancements between the AG's office and medical board staff. I am not sold on the idea that you need to physically be located in the same office, but I am agree completely with Dave Thornton, Ms. Felmuth, my entire executive team, that we do need to have the infrastructure in place to improve coordination, to be able to show a seamless communication, and that's what the IT infrastructure seeks to do. So that's really the key things. Our VE model is proposed to be extended to 2013 in a bill that was heard and passed by this committee, and that's AB 1070, Hill's bill.
Okay, thank you. Next.
Good morning. Paul Riches, Executive Officer for the Board of Behavioral Sciences. I think in terms of, I'd like to do a couple things, highlight a recent program change we've made on the investigation side, which may have some utility for folks, and make a couple observations just for the committee's consideration. First, starting in fiscal year 2008-2009, the board obtained 2 non-sworn investigative staff. We brought those staff on in November of last year, and after some very intensive upfront training that we'll be continuing, have put them in the field. And in that time period, we have reduced our investigation backlog by 50%. We'll be making a full report to the legislature next March, pursuant with the BCP that gave us the positions, but so far it has proven a very useful model for us, and I think it's a replicable model for other boards. But I do want to qualify that with, for a certain universe of cases. In that same time period, we have continued to refer a number of cases to the Division of Investigation at DCA, who's the body we relied on to do field work before this, because there are still cases on a day-to-day basis that aren't appropriate for non-sworn investigators. And I think one of the things in any investigatory model is that you have a diversity of resources available. The key for us is to match the investigative resource with the needs of the case at hand. And I'm only dogmatic about that. I think otherwise being dogmatic about models doesn't work well in the real-world environment. But I do think there's a lot of potential there for other agencies, and I think the early results for us have been very positive, and we're hoping that's going to continue, and I believe it will continue. A couple of observations I'd just like to make in terms of listening to the testimony today and things that I think about when trying to sort these things out. One is, I think it's really important in any organization to align authority and responsibility as much as possible. Where you tend to see problems in any organization is where the responsibility for doing something lies in a different place than the authority to have it done. And I think when those two things aren't in the same place, you can create problems. And I think that ought to be front in all of our minds and thinking about how do you set up an enforcement process that works. Because I think aligning those things matters a lot to making organizations work well. I think the other issue that strikes me immediately, and I think quite appropriately, there's been a lot of discussion about the medical board model and what's going on with the Bureau of Registered Nursing, but I do think we need to be mindful that I believe there's 17 or 18 healing arts boards at DCA. Radical issues of scale. Dave Thornton was talking about a $51 million annual budget. I don't know what it is this year for MedBoard. BBS, we're kind of middle of the pack. I have a $7 million budget for my whole agency, and there are a lot of boards that are smaller than we are. And thinking about how any set of solutions you bring forward work at different levels of scale, I think is really important, because you can go from very large entities like the medical board to very small entities in the department like the Board of Optometry. It would be hard to find two boards that are more differently situated in terms of resources, needs, and the nature of their cases, and I think the models ought to take some consideration to that in thinking about how do you apply things in the long run. I think lastly, I'd like to make one other point, and that is all of us want to do our cases. We want to do them quickly, and I think what I'm looking for is giving the boards the most useful, diverse set of tools available to make that happen. And really, at the end of the day, our responsibility as boards to prosecute the cases, and we've got to figure out a way to do that with the resources we've got. But if you give us more and better tools, I'm pretty confident you're going to see better results. Thank you.
Hello, my name is Teresa Bello-Jones, and I'm the Executive Officer of the Board of Vocational Nursing and Psychiatric Technicians. And it is hard to talk without looking at my notes because I had all these great points for you, my dear. But for our board, we've always been a board that hasn't had a lot of money, and Bill Gage knows that. And we say necessity is the mama of invention at our board. So through the years, what we've done with, as you've heard, decreased resources, decreased staff, is that we've looked at what's the best thing to do with respect to getting our cases finished, complete, out, and disciplining those that need discipline. We always believe that communication and connection with the public is crucial to inform everyone about what our licensees do, what they shouldn't be doing, and how to get to our board to file complaints. We've done that in any way that we can with pamphlets, on the internet, any way we can, meetings. We also, in 1996, we implemented our fingerprinting program. Of course, we couldn't do the whole group because we didn't have enough money to do that, and we knew that we wouldn't be able to get the money. And we did implement mandatory reporting, as you've heard and seen in reports. We did do that because we looked around and said, what are the trends and what's going on in the rest of the country? And we spotted this guy in New York that was going from place to place, and we said, we don't want him in our state. Let's do mandatory reporting. And we did that in 2004, and it took us about 4 years to finally get it through. We also have our licensees, they're required to report their other licensees. The LVNs report LVNs that are not doing what they're supposed to be doing in their scopes of practice, and our psych techs do the same. We also have been serving our own accusations and preparing our own default decisions, again, because of money, and we couldn't afford to pay the Attorney General the money that we had to do. And we were one of the boards that the Attorney General would come to us and say, Teresa, you're running out of money. Not that we're saying we're telling them we're running out of money and to stop our cases, but we're also one of those boards. But wherever we could, we would redirect our funds and make sure that the AG would get money to continue with our cases. So that's another what we think was a best practice for us. We also continue to look at, as I mentioned earlier, trends and what's going on. So we try to ask for legislation and regulations that would improve our enforcement program. And, well, of course, one was mandatory reporting. There's others that we have that we've been refused a couple times, but just as Julie says with CPIL, we keep coming back and asking, we keep coming back and asking, and we'll be doing that again soon. Also, last but not least, I just want to say that another best practice is looking at your staff recruitment and development. You've got to get staff that are dedicated, and you have to develop them to look at enforcement the way that we look at enforcement, and that is quality enforcement. And when people, staff, they look at all these cases that we have, and these difficult cases, complex cases, and they know we don't have a lot of money to continue, you need to have somebody that's going to say, we're going to go forward, we're going to move, we're going to do whatever it is we need to do to get these cases done. And we do have that kind of staff, and I'm sure all of the boards do too, but that's one thing that's very important that we should not forget, and that's our staffs. Thank you.
Good morning. I'm Richard DeCure. I'm the Interim Executive Officer for the Dental Board of California. And I have been with the board probably on and off more years than any of us in this room want to count. I think that what is critical here is that there's a piece of the dental board that may have been overlooked that's critical, and that is the dental board has its own sworn investigators within its own walls. We have 17 sworn investigators. 3 of those sworn are supervisors, so we have 14 rank and file. That allows us the ability on high priority cases, death cases, drug cases, sexual molestation or sexual cases to immediately send investigators to the site on the scene same day when necessary. And if it's a different day, then we calculate what those days are. That makes us, on those high priority cases, very, very responsive. On October 5th, the board's president and vice president, the vice president is here, his name is Dr. John Bettinger, canceled his patients to come listen to the hearing.
Where's he at? He waved.
Dr. Bettinger. I think he's hiding, but I don't know for sure. But we did look at our own system to see how it might be improved. And I do believe that that blend of non-sworn and sworn might be a better way to deal with all of the cases, because not all the cases are death cases. They're not all drug cases. There are a lot of quality. The majority are quality of care cases, where negligence, simple negligence, gross negligence. We also looked at, as Barbara said, we looked at the tracking system. The tracking system clearly needs to be revamped. I don't think anybody will disagree. I think in general we all agree that the system in many ways is broken down. With respect to vertical enforcement, vertical prosecution, I can't specifically speak to that issue because it hasn't affected us, but I would say any system that takes the investigators out of our own offices is going to reduce our effectiveness to be responsive to the citizens of California. We do believe that. When a call comes in, I had one 2 weeks ago, closer to this building than you would want to know, and I wasn't able to call up our enforcement chief who's here, send an investigator out within 3 hours, and they were on the individual's in the individual's office. So we are very responsive, especially to those high priority cases.
We were wondering why that member was acting goofy.
I'm going to take the fifth on that one. And with respect to diversion, like our enforcement system, is also inside the walls of the board's programs. There are cases where we get our investigators that go out, they will refer the individual to the diversion program. There are times where we don't have sufficient evidence to move to take administrative action on an individual. We had one recently where they went into the individual's office, the drug test came up negative, they persuaded him inpatient. He's been inpatient and out of practice for over 6 months. We could not have done that had we followed the standard process, the standard prosecution process. So there are other cases where we get anonymous complaints in and we send them straight to the investigators, and the investigators go out. Whether they come into diversion is more based upon whether or not we can get an immediate suspension and get them into rehabilitation. So for us, the Director of Consumer Affairs has made suggestions that go far beyond what we can do, and we believe that the majority of them, vast majority, maybe not diversion, but the vast majority are things that we can implement, and we certainly welcome. Lastly, as you know, we had a bill, AB 456, come through this committee, and that bill was intended to allow records on cases who are individuals who are on probation, in diversion, were terminated for noncompliance. It allowed for all of that information to be used for discipline, which is something that the existing law does not allow us to do. We were trying to get that bill consistent with SB 1441. We ran out of time. We'll revisit that bill again next year. So our board, we believe, has been quite proactive. Thank you very much.
Thank you very much.
Can I just say that? I neglected to say that Barbara Yaroslavsky, the president of the medical board, flew up from Los Angeles also today for this hearing.
There you are. Okay, thank you. Okay, the next panel. And if you'll do the same thing, just kind of tell us what your best practices are. Virginia Herald, Jim Rathensberger, and Brian Siegler, and Stephanie Nunez. You're also the head of that, too?
Former.
Oh, okay.
What a guy. There's an efficiency.
All right, go ahead and start.
I believe I'm first up. I'm Virginia Herald. I'm the Executive Officer of the Board of Pharmacy, and talking about some of our best practices. We're fortunate we have our own investigators that work in-house. Our investigators are, for the most part, all pharmacists. We have a few consumer complaint handlers that are non-pharmacists that we've used in recent years to help expand our capacity to investigate complaints, simply because our pharmacists are very expensive, and as important as it is to have them in the field, sometimes we don't need a pharmacist to do some of the things that we do. So we've divided that way. In terms of some of the best practices we have, the pharmacists ourselves work from home offices. They do not report to an office every day. They work directly from the home offices. They have full telecommunication devices. They use cars. They investigate from the field. One of the things we've recently implemented, which is one of the things that Brian indicated earlier, right now all of our files are moved back and forth from the complaint assignment stage to the investigator stage to the supervisor review stage back to the Sacramento office, with paper files being moved back and forth from the Sacramento office. We're stepping away from that. We're going to do everything online, which is going to be a revolutionary change to us. We believe we can shave at least 6 weeks off the time to investigate a complaint by doing that. We're one of the faster agencies, I think, in part because we do have our own complaint investigators, and they also understand the law.
Just a minute. Thank you. My feet are already blocked, so you know. My legs are frozen in here.
Oh, yeah.
Yes.
Actually, it feels kind of warm to me.
Okay.
But the jacket's still on. We have some mandatory reporting requirements.
Women of a certain age.
Well, you're assuming that yes. I need to go see that plastic surgeon. We have mandatory reporting requirements in our law that greatly help us with our investigatory functions and our reporting functions. For example, if a pharmacist is laid off or fired because of suspected drug abuse or mental illness, it has to be reported to the Board of Pharmacy. That's an important impetus for our investigation. So we get certain information early on. Any controlled substance that's lost by a licensed facility has to be reported. If it's a pharmacy, it has to be reported to us. So that's a grounds for us to initiate investigations on drug diversion of controlled substances, which unfortunately is a significant problem for us in our licensees.
I was just going to ask you, do you know what the percentage is?
No, but even one's too many. We receive hundreds of DEA loss reports. When the economy gets bad, we oddly get more. It's interesting we just lose drugs, controlled drugs, and they have to report any loss. So it's beneficial to us to have those reports. We screen them, we go out. We spend a great deal of time working with the FBI, with the Drug Enforcement Administration, with the FDA on criminal convictions where drugs are moved across state lines involving really serious drug diversion, tampering, things along that line. Those are high-level investigation cases, and our pharmacists are very beneficial to those law enforcement agencies because they don't know the drugs the way our investigators do. So most of our cases, I'm not sure, would be totally benefited by the vertical integration model, enforcement model. We right now use our Deputy Attorney General liaison very closely on complex cases where our investigators and the supervisors aren't familiar with the cases, or it's a new area. For example, if petition to compel, we rarely do them, so when we do, we need the guidance. We use our AG liaison for that function. For investigating fraud, for investigating a med error, for investigating self-use, we generally don't need the assistance of an attorney because our investigators are already trained, and the supervisors who oversee them also outline the components at the front end of the investigation. They also work closely with the inspectors to make sure the cases come in. That's part of the reason our case closure time is just a little over 180 days. So it's still too long. We need to be faster. Let's see if there's anything else. We have good ability to access records in the field. Our statute gives us that authority, and where it's weak, we're able to get investigatory subpoenas from the director's office, and we make use of that. We are now, other things we're doing is since the beginning of the year, we set up a criminal complaint unit to set and completely review the criminal convictions. That was a workload that was a problem for us. Over the last 10 years, we've had a 60% growth in the number of our licensees and a 57% growth in the number of our complaints. So they seem to be rising together. We have a fee bill on the floor of the Senate to increase our fees. We hit the statutory max in January 2009. We are now seeking a fee increase because we recognize we do need additional staff in order to do this. One of the things that we're hoping to be able to do once we get a fee increase is do mandatory inspections of all of our sites every 2 years on an unannounced random basis, because if you're not in looking, if we're only out investigating complaints, it's extremely reactive. We want to be far more proactive and stop problems before they get large. And lastly, on the one, I think that I'll close with one more thing because it's been a long morning. One of the things that we've all been talking about in here today has been more of a reactive model. We're waiting for the complaint to come to us instead of initiating an investigation and outreach to the public. The Board of Pharmacy has 2 posters that have to be posted in every pharmacy, much like the Bureau of Automotive Repair does, that lists our name, how to contact us, what a patient's right is to medication, and questions they should know the answers to before they receive medicine. We believe those 2 posters that we do enforce against to make sure those posters are displayed are beneficial to help alerting some of the public that the Board of Pharmacy exists. Here's how to contact us.
Thank you. I'm going to let you go last so you can hear everybody, so go ahead.
Okay. Well, our take on it is we're going to go back.
What's your name?
Oh, I'm sorry. My name is Stephanie Nunez. I'm with the Respiratory Care Board. And starting in about 2000, we started really looking at how to do our enforcement cases different. And we've tried different investigative units. We've gone to the medical board. We've gone to the Division of Investigation. We just had problems with both of those agencies. And so we started to say, what can we do ourselves? So we started to get these criminal records. A lot of our cases are criminal, at least they were at that time. And so we started using our own staff to get these criminal records. A lot of agencies do this now. Not all of them, I don't think. They're able to get the certified documents, and that in itself is enough to forward to the AG to prosecute a case. In 2001 or so, we also have implemented mandatory reporting. So employers do have to report to us if they terminate or suspend an employee for different causes. And with that, we started getting a little bit more of the patient-related types of complaints. Again, we really try to use our own staff to get the documents because we have so many problems with that. We do not have subpoena authority. That's one thing that we really would like to have, because there are few cases that we could have just sped up a lot, and those do need to go to the Division of Investigation, where it can take up to 9 to 12 months to get the records. Let's see. We also went through our probation program. We revisited every term and condition. We got rid of the loopholes in that, and worked with the AG. They were refusing a lot of cases back in the late 90s because, they didn't think it was a violation. So we really fine-tuned that. We have all of our disciplinary actions online. We also have them linked to the online license verification system, which is not, I think, in effect for everybody. So when you look up a license and you see there's an accusation, you can click on it and actually read the accusation. We also established a cite and fine program in the early 2000s. And then I'm not sure if everybody has that, but when we did that, it was a great way to prioritize our cases instead of sending every single case to the AG. And we've gotten a lot of positive feedback for that. We were able to cite and fine them, make sure that we can use that as aggravating evidence in the future if there is a pattern behavior. And another thing that's been very helpful is that we use a paralegal over at the AG's office. Anything in Northern California goes to this one paralegal. She's absolutely outstanding. She's able to get to these pleadings quickly, get them filed. Our office actually files them ourselves, which I don't think is the case at all boards. And we have, we got a lot of statutes for cost recovery. We have contracted with a collection agency to recover some of the costs. Again, trying to make sure the good licensees aren't paying for the enforcement. We also have a mandate that requires an ALJ to revoke for sexually related crimes, whether it's with the patient or not. It's based on the education code. We also obtain work schedules from our probationers as part of our probation program so that we can pop in anytime and make sure that they're there and test them if we need to. I think that's going to be summing it up for now.
Okay, thank you.
I'm Jim Roethlisberger, Board of Podiatric Medicine. The Board of Podiatric Medicine is actually part of the medical board. And although we have our own board members, we're part and parcel of the medical board. We're fully integrated into its complaint intake, investigation, and discipline coordination units. I did institute almost 20 years ago a full-time enforcement coordinator in our office to try to help expedite all these cases through the system. And I think that's been replicated elsewhere in a number of boards. Our board strongly supported the first Presley bill to strengthen physician discipline, SB 2375 of 1990. In fact, we were the first state agency to support it. And we have supported all the CPIL legislation since then. And Senator Presley actually served on our board as an appointee of the Senate and served 2 terms on the board and 2 terms as president. And, helped working with the medical board and CPIL, helped push a lot of these reforms that Julie D'Angelo talked about, over some real opposition. Now our board, we've had some good input, and we are strongly supportive of the administration's recommendations and think there's a lot of merit there, and it's a consensus set of proposals that many of us can support, and our board's going to be supporting those. In terms of things that may make us, that other things we've done, one thing I would mention is that working in concert with this committee, our board sunsetted this diversion program in 1998. That was part of SB 1981. And it was our sense that there were programs in the private sector that could do those programs, and we were not comfortable with that being part of our program. So now any licensee can go into a private diversion program confidentially on their own. If it comes to our attention, it will be a term and condition of probation. I think when we legislated that in 1998, there was an idea of observing it and seeing how it would work, and there have not been any problems with sunsetting diversion. So I was glad to see the administration considering that.
I hear somebody's phone. I have good ears. Okay, that's it.
I'll stop there and answer any questions.
So you've kind of heard everybody. You've kind of heard some.
Brian Steger, former executive officer for the Board of Chiropractic Examiners. And I'd also like to say that one of our board members, Dr. Hugh Lupkin, is here. He canceled his patients.
Okay.
2 years ago, the board had an urgent need to reform its enforcement program very, very quickly. And so I'm just going to tell you some of the things that we did to reduce our backlog by 50% and also to reduce the average case completion time. It was from 5 years down to about a little over 2.5 years. I think by the end of this fiscal year, the board will be fully caught up with the backlog and probably have their case completion times down to about 18 months. These are really practical steps. We establish accountability by assigning each complaint to a compliance analyst. That analyst reports on a monthly basis to their manager how they're doing. We develop written guidelines to prioritize complaints. We focus on our urgent complaints. We cross-trained our compliance analysts in all aspects of complaint handling, investigation, administrative discipline, and probation monitoring. So from beginning to end, each of our compliance analysts know everything there is to know about that process. We established our own in-house special investigators for the first time, and they're working out great, much like the other boards. We provided formal investigative training to all of our enforcement personnel, so all of our staff goes through the same investigative training that the investigators go through. The board adopted regulations to attach monetary fines to citations for the first time. The board also adopted regulations to issue what's called the letter of admonishment because we wanted to give our folks enough tools to take action to change behavior. The compliance unit also developed desk procedures that also include timeframes. These are expectations. We reformed our expert review and expert witness program. In the past, it took us several months to get a written opinion from our experts. Over the past year, our average time to get these reports back now are under 30 days, actually 28 days, which speeds up enforcement. We also fully utilize the mandatory reporting and subsequent arrest reports to initiate investigations, meaning that we no longer wait for convictions to come forth on certain arrests. And then finally, we issued citations with fines if patient records were not provided, because before you can really complete that investigation in a quality of care case, you have to have those patient records. So we implemented several of these really practical, easy kind of things to do, and then all of a sudden we were able to reduce the backlog by 50%.
Thank you.
Okay.
And just so you know, since this committee deals with all the licensees with the exception of the lawyers, I just want to let you know that our office will work with you in any way we can, in any way that you can help us.
I appreciate that, Madam Chair.
Okay. Thank you very much.
One quick comment, or else it'll be a very long afternoon for me. I have my president, Dr. Ken Schell, in the audience as well, who did not give up seeing patients today, but he did come in.
Okay, thank you. All right, now we have the last panel, which is the response from the nursing profession. And just so you know, they're going to shut us off on the televising at 12 o'clock. So if you all just tell me your names ahead of time, then you'll be on the record.
Okay.
So why don't we go ahead and start with you. Ma'am, go ahead.
Okay. My name is Ingela Dahlgren. I am a critical care nurse of 31 years, and I am here representing SEIU Nurse Alliance of California. I have recently become the executive director of the Nurse Alliance of California.
Okay. Go ahead.
My name is Sarani Kwan, and I'm a nurse practitioner, and I'm here on behalf of the California Association of Nurse Practitioners.
Okay. Tricia Hunter, American Nurses Association, California.
Deanne McEwen. I'm a registered nurse, intensive care.